Good evening, everyone. Ladies and gentlemen, esteemed members of the Planning Board and valued community representatives, I welcome you all to this evening's assembly of the Saco Planning Board. As chairman, it is my privilege to convene this gathering dedicated to the thoughtful planning and development of our community. Today, we come together with a shared commitment to shaping the future of our city in a manner that reflects our values, respects our heritage, and fulfills the needs of our residents both now and in the future. Our agenda tonight contains important matters, each requiring our careful consideration, expertise, and collaboration. As we engage in our deliberations, let us remember the profound impact these decisions will have on the lives of all, keeping in mind we're residents like you. It is our duty to maintain transparency, fairness, and inclusivity in our proceedings, ensuring that the voices of all are heard and respected. Together, we must embrace the responsibility entrusted to us by our community, working diligently and thoughtfully to chart a course that fosters growth, prosperity, and harmony. With that, I would like to call this meeting of the Tuesday, February 3rd, 2026 Saco Planning Board to order. I look forward to the productive discussions and meaningful outcomes that lie ahead. Thank you. With us this evening, myself, Matt Provenzel, the chair of the board. To my left, we have our vice chair, Joyce Leary Clark, along with planning board members Jeff Brochu, Catherine Palini, and to my right, Jim Mollier, and a newly appointed, or confirmed, I should say, planning board member, Chris Gagnon. With us as well this evening, we have our city staff members, our city planner, Charles Tettleman, along with our planning compliance manager, Lisa Harmon. And with us, as always, our City Council liaison, Nathan Johnson from Ward 7. Our first item on our agenda this evening is a review of our meeting minutes. And we have minutes this evening from January 20th, 2026 to review. Any questions, comments, or edits on that draft from any board members?
Mr. Chair, I'd move to approve the January 20th meeting minutes as presented.
Second. Was that a second by Jim? Sorry. All right, thank you.
It used to be easy, but now you have two voices.
It was so quick, I'm just making sure now. Now I'm going to have to look. I'll get used to Chris's voice. Thank you for the motion in the second. Any additional discussion? All right, those in favor. Chris?
Abstain. I wasn't at the previous meeting.
Sure. Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 5-0 with one abstention. Our next item on our agenda this evening is our Planning Board Public Hearing Guidelines. This is a document developed by the board and city staff outlining the procedure in place for our public hearings held. This explains the purpose of the public hearings, the outlined procedure of reviewing an application, and public comment presentation and meeting duration. If anyone has any questions on this document, please let us know. There are hard copies available at the rear of the auditorium, along with digital copies on the city's website. Our next item on our agenda this evening is our public comment period. This is where we will open our public comment period to hear from members of the public. This comment period is limited to a total of 15 minutes to items not under Planning Board review. The Planning Board appreciates public comments and knows the public comment about matters before it helps the board understand neighborhood concerns, review an application, or help address an outstanding item. Those wishing to make statements about an application under Planning Board's review are asked to provide those statements during the applicable public hearing period. Comments during this period are limited to 3 minutes. If there are multiple members of the public looking to speak, we may reduce or adjust that 3-minute period per person to accommodate all speakers. If anyone is with us this evening, would like to come to the podium and discuss any matters, please do so. State your name and address for the record, and we will collect those comments and address them accordingly.
Hello, everyone. I'm Kelly Archer, 185 Bradley Street, and welcome. I'm sorry, Douglas? Doug?
Chris.
Couldn't read that far. Oh, I'm looking at Ward 1 counselors. Sorry. Chris, welcome. This public comment is going to be a little bit awkward for me. I don't like doing this. However, one thing you should know about me is that I'm always forthright. And I always state any disclaimer if I do not have the receipts. I always have receipts when I speak. I'm talking about the last SOP meeting. Prior to that last SOP meeting, I didn't email everyone, which is normally my MO. Everybody gets emails in the city. I just emailed the chair, the planner, and the city council liaison. And it was about concerns and suggestions on the SOP at the last meeting. So prior to that last SOP meeting, I emailed the planner, chair, council liaison about my concerns and suggestions. Sorry about the repeat. The reply was, I'll bring your concerns and suggestions into the conversation tomorrow. That response was my expectation. Therefore, I did not come up to the public comment period because I thought that email was going to be addressed as it was stated. After the meeting, I immediately addressed the chair and the planner as to why. The planner responded that he spoke with the deputy chief and stated it didn't have to, that the members could. You received the after the fact packet, and at the very end, I did see a couple pick it up, but it wasn't read. And I felt it was a disservice to my suggestions. So here I am on that last paragraph of that letter that you all received. I am also advocating for the formal inclusion of a public comment segment, specifically during application completeness reviews. Currently, the public is often limited to submitting written letters or using the general 15-minute public comment period to adjust these technical terms, which distracts from other non-agenda concerns. Allowing residents to address the board directly on matters of completeness ensures a more thorough and accountable review process, providing a formal space for the public to highlight potential omissions, such as missing environmental data or neighborhood-specific impacts before an application is deemed complete, aligns with the board's duty to gather evidence to inform their decisions. This proactive approach prevents critical data from being overlooked in the early phases prior to the public hearing and ensures the applicant meets their burden to demonstrate compliance with city standards from the very beginning. So I'm requesting that you consider in your SOP in any application completeness, because there is no public hearing, but we have vital information to share with you. And it should not be at the public comment period, and it shouldn't be at letters. We should be able to hear the applicants, hear your dialogue, and be able to speak in the same moment of that agenda. And I believe it should be a public comment and not a public hearing, because that's not what it is. That would be following after. Thank you for listening.
Thank you. All right, we will continue with our agenda this evening. Our next item is item 6. This is our planning application review and public hearings. We have 3 items on this agenda this evening. What we'll do is we'll introduce each one individually, we'll get an update from the planner, and then we'll invite the applicant and/or their representatives to the podium here to give a presentation or any updates that we have. So with that, our first item in our public hearing agenda is 184 Simpson Road. This is map 121, lot 06, and this is Ecology Education, Inc. Board members, any conflicts or disclosures before we begin this item? Great. And Charles, do we have any updates on this item before we begin?
Yeah, I will just bring up the after-the-fact packet. There is, I think, 4 items, 4 or 5 items that are in the after-the-fact packet for this application. One of them is just clarifying a previous public comment submission that was discussed via email. So clarifying that one of the previous public comment is now listed as public comment 28. And it just adds an attachment that I missed in the upload. But just for clarification, at the after-the-fact packet that was physically handed out at the previous meeting, that attachment was included, just not in the digital copy, so I just re-uploaded it as its own separate public comment, and that's in the after-the-fact packet.
All right, great, thank you. Board members, any questions for staff at this time? All right, great, and we have the applicant with us this evening. I think if you'd like to come on up and give us any updates. Introduction, presentation, anything you have?
Certainly. Thank you. Hope we're okay on audio. I apologize, I'm getting over a cold, so if it sounds like I'm about to cough or sneeze at you, I may. Nice to see you again. Good evening. My name is Peter Van Hemmel from Bernstein Schur on behalf of the Ecology School. I wanted to review a couple things. First, I think the submissions that were offered into the record, the written submissions, including a letter that I sent on the 14th of January, address the open and pending issues that have been continued for hearing from what was a prior meeting on December 16th. And so I hope the board has received appropriate information and the planning staff has all the data that it needs on what I think is a fairly limited scope of review. The 2 items that were continued for additional information were first, the technical capacity or specifications, whether the applicant has provided sufficient information for what is now the town's Public Works Division to complete the left turn lane project. I'm confident that that information has been presented, and I've heard no questions or reactions back to the information that has been with the staff, so I hope that that's been complete and has been presented by the project engineers to the city engineers and relevant staff as needed. And second, the other issue was the applicant's financial capacity, which has been discussed in the letter, and hopefully some of the materials that were under question in the first meeting. I think there was some question about the city's loan documents, and I have responded to that, I think, in the written submission, but I'm happy to clarify any open issues. I think the review for the board, ongoing as it may be, is fairly limited in terms of the information that has been provided, and some of the purposes that were sort of added to that I thought were superfluous to the board's review, and I'm trying not to turn this into a sort of character issue for the applicant, and I think the board is familiar with, you know, the standards that apply for a project review do not include who's a good guy or who's a bad guy. It's everybody's equally entitled to planning board. Is that close enough? Thank you. Sorry. I appreciate that. Everybody is entitled to the same process before the planning board and the same standards of review for application, regardless of how their profile may be perceived. And so I think that the project stands on its merits as submitted, and that there is no need for the planning board to do an inquiry into who's a good guy or who's a bad guy. I think that's off the mark, as I think I identified when that issue came up in the first instance. Second, I think it is significant to address some of the questions that were raised in the continued hearing in the context of what happens if this standard is not approved, the extension for time. And I think there's an interesting sort of series of consequences that flows from that. The first is, if there's no approval of the extension and the left turn lane project is not approved as a result for construction, there's a lot of money that needs to come back to the ecology school. Hundreds of thousands of dollars, which is on account with the city, needs to be immediately and fully refunded to the ecology school, which I'll characterize as great if that happens. So just want to be clear that the city does not get to keep the money, and perhaps this goes without saying, but that is a deposit in connection with the project, and if the project is not green-lit, so to speak, those funds flow back to the ecology school, which is in dire need of those funds. That'd be great for programming and other applications. The second thing that happens is the city currently holds a mortgage under which some payment has been made for the city's financed portion of the project. That needs to be immediately canceled and released. The city's interest is solely based on the project being funded and paid for in this way, and if the planning board doesn't approve that portion of the project, great. City has to release its mortgage immediately and refund a payment that's been made under that mortgage. There's no right for the city to keep it. The third sort of forecast around this would be one of the requirements that the city has made through staff, and I think the board has seen this previously, were traffic studies, which the engineer of record on that is Sebago Technics. I think the city engineer has accepted these findings without comment. And the last findings and last reports, I think, were that the left turn lane is likely merited by traffic count that's independent of the ecology school. So it appears, and I can't be sure of this, I do not make decisions in terms of traffic improvements for the city of Saco. Obviously, that's under a different process. But it's highly likely that the city has to build this left turn lane anyway, with no funding from the ecology school. Also, no funding from the state. They're not going to pay for that. They only pay for that through the BPI project, which is part of this application. So what is currently 3/3 of a project funded by non-Saco taxpayers becomes fully funded by Saco taxpayers if this application is not approved. That, again, is up to the city, and I don't make the city's fiscal policy, but it's highly likely, based on the engineering reports, that the left turn lane is justified independently, and the money which is currently allocated and before you to pay for it vanishes. So that is a sort of consequential application in terms of some of the comments as to the responsibility for taxpayer funds and for some of the accounting risks that attend this project. So I think that there would also be likely, and we'd have to talk about this with the board, there would need to be some amendment to the condition. I'm not sure what that would be. As a result of that, we'll have to play it by ear in terms of where the application and the outcome goes. But if the city, which now has the technical specifications, all of the money needed to build the project, and contracts which obligate it to do so, right? It's signed a contract with MDOT that says it will do this. If the city doesn't do that by its own election, okay, but we would likely seek to modify the condition which drives this. So I just wanted to sort of fill that out because I think that that was sort of left hanging with some of the comments that you received last time around. So, excuse me, I'm trying to clear my throat into the microphone. I apologize for that. But that, I think, is where we are in terms of the completeness of the open conditions that were continued for hearing. I hope that we've responded to that fully and fairly. And I think that I wanted to provide that extra context for the city's decision that it's obviously up to the bodies of Saco as to whether that left turn lane happens or not. But if it doesn't, there's definitely some money coming back to my clients quite a bit, quite soon. So I leave that with you in terms of where that goes, and will remain available for comments and questions. Happy to take some now if there are any, but I can also stand down and let others speak or take questions as they come.
Great, thank you. Any questions from board members? Jeff?
Sure, Mr. Chair. Thank you. Trying to stay focused here on, our task of an extension of a condition of approval for a site plan. And yes, there's a lot of information out here. We're worrying about financial capacity, technical capacity. Can you tell me, did your client entered into a mortgage with the city of Saco to fund their third and this agreement for the construction and the business partnership initiative? That took place on May 24th, 2024, approximately?
I can't remember the date, but certainly that's when the entered it. I do have the mortgage deed, which was dated, bear with me, May 24th, 2024. Yes.
And was it on the same day, because the packet did not show, was it the same day that they signed the construction loan agreement with the city of Saco?
It would have been part of the same package.
Okay. So,
Hold on, I have that. Let me check. It is undated,
that's what
but I assume it would have been the same day.
I'm just assuming that you could, as a representative, agree that it was the same day or very close to.
Yeah, it would have been.
Okay.
Yeah, we negotiated them together.
So I was looking through that, and I was trying to understand, because it seems like I'm always trying to put a timeline together with this project that's been going on for 7 years, that under that agreement, that was the construction loan agreement, line item number 6 was the project timeline. And as we all know, we're talking about all project work shall be completed by October 2025, except any landscaping, if necessary, must be planted in the spring. Now that we're here, because we've missed that deadline and we're looking for an extension. And TES was supposed to provide the city with an anticipated design and construction timeline within 30 days of this agreement. By my understanding, that didn't happen because the information that you submitted or your client submitted from Sebago Technics had their 50% completion, I believe was dated August 27th, so some 90 days after the signing of the agreement. August 27th, the 50% design was submitted. So we missed the very first deadline. And then reading a little further in that number 6, the next paragraph talks about, should the project be delayed during construction for any reason outside the control of TES? The city covenants would be reconsidered and abated enforcement of the current October 2025 completion date if necessary. Well, I mean, we haven't made it to construction stage, and isn't it true that the Sebago Technics stopped their design work because of lack of payment? So there was an invoice that was sent on September 23rd, 2024 that was not paid until July 15th, 2025. And if I'm correct, the city made the payment on your behalf, your client's behalf. Is that correct?
I wouldn't say that, no. That is not correct.
Okay. Well, would we agree that's approximately 295 days after invoicing? So Sebago Technics kind of, it sounds like they were working, but they were also waiting for a second invoice that was dated November 19th, 2024, which didn't get paid until December 3rd, 2025. So they weren't paid for the design until 2 years after after the project should have been completed. So I'm a little bit perplexed here. You know, they were supposed to give the 50% design in 30 days. They didn't do it. This timeline says anything that's outside the reasonable control of TES. TES didn't pay for the design.
That is also incorrect. I'd be happy to respond to this.
Well, no, I'm just trying to get this timeline moving, because I'm hearing a lot about city staff not doing their part. And I believe in your correspondence to us dated the 14th, you kind of said, well, TES has done everything in their responsibility, and now it's 100% on the city staff to complete the project with MDOT. Is that the way I interpreted your wording?
Yeah, that's correct. At this point, the full amount of the payment, which was a contractual reserve account, was funded approximately by that date, yes.
No, but I mean, the interpretation is that the ecology school has done everything that they needed to under this requirement, and it is now 100% in the city's hands to manage this project.
As of that date, that's correct.
So what is the response to, because it does clearly say that the project is going to be performed via city-hired contractors and pursuant to contracts which TES is not a party, and TES has no functional role in the actual construction of the project, except for the design and engineering participation which shall run through the project. So I'm assuming that's the supervisory engineering services that typically takes place on all construction projects. So we're anticipating that your client's design engineering firm will be on site and paid to be overseeing this. So their obligation is not completed yet. Would you agree with that?
No,
You don't agree with that?
I do not agree with that.
Okay. Now, is it also on that May 24th, you entered in this mortgage with the city, but then we receive through public FOIA, or a public packet, a correspondence from the Elma B. Seawall Foundation, stating that they felt like they have first mortgage on this property, so that was signed over to the city, that predates the city of Saco's mortgage. So it just seems like there is a lot of pieces here that all fall, if we want to talk about technical capacity, financial capacity and technical ability, that I guess there's just a lot of pieces.
I'd be happy to try to clarify some of the questions.
So-
I think you have fundamental misunderstanding as to a number of facts here.
So I'm just trying to pull back to, we're looking for an exception or an extension to a condition of approval for a site plan. And if I bring us back to City Ordinance Chapter 179, 3.01, which is our site plan review process, under H, limits on approval, site plans and minor site plans, if substantial construction is not commenced within 24 months, the planning board of a site plan, the site plan shall be null and void, right? Well, we know this wasn't the actual site plan, it was a condition of approval, but we put it out there. And what they're asking for is an extension, right? And it says that we can extend under number 2, the deadline for substantial construction may be extended for a period, a singular period, of up to 12 months by the city planner upon written request of the applicant. And in this case, the city planner has kicked this request back to us because they didn't view it as a minor amendment. Well, if we can only do that once for 12 months, why are we talking about this for the third time, is my question. And if we continue down to 3B, basically saying the city planner, or in our case the board, shall approve the request for an extension unless one of the following occurs. B, failure to meet a condition of approval within the required time frame. Here again, we've been through this twice, they haven't met the condition of approval. So I don't think we can hear it. I mean, we basically need to say they haven't proven the technical capacity to get this done in a legitimate way. And it's just some of my thoughts. I think we're using a lot of board time for something that there's multiple things here. I mean, this really needs to go back to council. They need to see if these contracts are void. Can they hold up their 1/3 of the commitment if the city doesn't have that mortgage because a previous mortgage company says they have right to that? I mean, there's a lot of stuff here. I don't think we need to be extending this timeline. And whether the money goes back instantly or not, I mean, all we're looking at is a condition of approval. Condition of approval has not been met. It's going to be deferred to code enforcement for enforcement. That's our review. Why kind of continue to drag this out? So I'm kind of thinking we can move on this tonight and just not grant the extension. Thank you.
All right, thank you, Jeff. So just sort of recapping here, your big picture concern is, I guess, being able to review it based on our site plan ordinance and that the time frame built into there. You're sort of working through some of the time frame within the application package. That's sort of, did I get that right? I mean, I know there's a lot of pieces to the whole puzzle. I'm trying to grasp at the big picture.
The big picture, I think, in our ordinance is that I don't think we have the right to extend this a third time. Under our site plan ordinance, they can have one extension for 12 months. I don't think we have the right to extend it again. It's a condition. And if we wanted to, try to look at the overall capacity, it's part of a site plan review. Financial capacity comes into play. If they don't have the ability, or if the city doesn't have the ability anymore, that's why that all needs to go back to administration and council, to figure that piece out. But we don't have to give them the extension. They didn't fulfill it. We don't have to give the extension. It's a site plan. The site plan is still going to be in effect, and now they're dealing with the consequence of not fulfilling a condition of approval. It's not like we're being held here and the city's being captive. That's not our role to worry about the financial impact for everyone. That's the council's role. Let's send that back to the council and let them deal with that piece of it. But I think if we were challenged, we don't have the ability to grant another extension for this. And if we are permitted to go look at the technical capacity, they haven't proved any technical capacity. All they had to do was hire the contractor, and they didn't pay him for a year. So that's kind of where I'm.
Okay, thank you. Any other thoughts from board members? Joyce?
Yeah, there's a lot here. I would say, of course, I can't pull up the section that you're talking about right now, Jeff, but I mean, if we're talking about the planner having discretion to give a 12-month extension, that's just the planner having a 12-month extension. If we don't have, it doesn't say the planning board can't give more than one extension or a longer extension. We're talking about, minor site plan review. I would like to actually get the applicant's response to this if other people don't have questions. But I think we're talking about apples and oranges to some extent, that the planner does in certain circumstances have the right to approve a minor site plan review, a minor site plan amendment. This isn't what we're talking about. We're talking about something that's beyond the planner's discretion. So that's why it's in our laps.
Sure, thank you, Joyce. Any other thoughts? I had a couple. So in one of the letters, it talks about a December 3rd construction start. So that's that hasn't commenced, correct?
I'm not sure. Can you show me where that is?
Sure. Shows up a few times.
December 3rd?
Yep.
I'm sorry, a letter that I sent?
There's a letter. There's a letter dated December 10th. From the applicant. It talks about, in the last paragraph, the start of construction date is currently December 3rd, 2025.
That's quoting somebody else. That's quoting city staff, I believe.
So that's my question. That's not a real date. I know we have a sort of a timeline.
I don't want to speak for city staff. That's quoting them.
Okay.
Mr. Chair, are you referring to the Sebago Technics document that was dated, actually the 9th, but it's on page 5 of 35.
No, there's a letter in the packet, excuse me, Mr. Chair. There's a letter in the packet from the Ecology School, signed by Drew Dumps, dated December 10th, 2025. In the last paragraph, says, the BPI was fully executed. Actually, let's see here. I'm just backing up a little bit. City staff memo to City Council. So it's quoting city staff memo to City Council from May 30th, 2025. The BPI was fully executed on June 3rd, 2024. Therefore, the start of construction date is currently December 3rd, 2025, with a completion date of June 3rd, 2027.
Which I think is what we're asking for the extension.
Right, I think that's why we discussed previously the reason why the extension request was, in our view, considered timely, I don't know if we ever addressed that, but we discussed the fact that it was timely because it was submitted before December 3rd.
Correct.
But yeah, it's the December 10th letter from the Ecology School to the board.
Okay. So then maybe for Charles here for a moment, do we have, I couldn't seem to find it in our application, do we have an update on any of the required easements for the project for construction?
There's nothing on the construction piece of things, there's no updates. I think we're still working on our end to do the easements, contact property owners, and create those. I haven't received an update from DPW on that. What I will clarify just on that last email is that was in reference to the BPI, and that was to meet the BPI deadlines, but we also provided a separate email communication between DOT and DPW that says like the 18 months, the agreement suggests that construction shall commence within 18 months. That's that December 3rd date. But the DOT confirmed that the agreement is good for 36 months as long as construction is completed by that 2027 date. That's the attachment A under staff attachments, just MDOT and DPW correspondence on the BPI. So those were just timelines in the BPI, and we got confirmation from DOT that their main concern is that 36-month January 2027 date.
Sure. Okay, thank you.
Thank you.
So as it sits today, maybe a general question for all. As it sits today, what's preventing the start of construction for this? Is the condition of approval can construction not occur until this is resolved? Is that how I understand it? I guess that's not my understanding, but my question.
I think the last I've heard from DPW is that we're going forward with the easements, writing those easements, preparing for it. I'm not a construction expert. My instinct is telling me that they wouldn't be doing that construction work now anyway. I believe DOT has certain times where you can do that type of road work. Not too sure, but what I can do is get more information on DPW. I do believe we're carrying forward in terms of our construction. There's nothing that I feel on our end that's holding up. We're just going through easements, which is working with attorneys, working with property owners, and I think that's what Director Moore reported at the or not this planning board meeting or the last, but the previous planning board meeting.
Okay, so no one is on hold waiting for the planning board to make a decision. There's still wheels in motion, moving everything forward.
I believe, just looking at the memo that Director Moore sent dated December 9th, that's in your packet as well, that what we kind of the city kind of started going forward with the next steps of contacting property owners where easements are needed, as well as discussions with utility owners to relocate utilities. Once easements are signed and utility work is scheduled to be completed, the city will advertise the job for project competitive bid. So I think he outlined the next steps in the process in that memo of what the city is, and I believe we're still in that contacting property owners, getting easements written, and working with utility companies. And that's the most recent update I have.
Sure. Thank you. I think my next question is, so there's I guess forgive me, I don't understand the amendment before us for a condition of approval. So without the amendment, the applicant hasn't met the condition of approval, right? It just breaking this down for a moment, trying to create some simplicity. Is it as simple as that? I mean, there's a condition of approval for site plan, and it hasn't been met because of the date. But that doesn't stop the applicant from meeting the condition.
Yeah,
right?
There's a couple things at play here. There's the condition of approval, which is kind of where this project is housed. So it's under that. It's been amended twice or three times, I forget exactly. And then there's also the construction loan agreement, which is separate from the planning board. That's a city applicant thing that was not a part of the planning board. That's related to the BPI, construction management, mortgage deed, all that. I would say for both, and we heard from one of the code enforcement officers, David Tomey, about this, is that our recommendation for compliance would be come back to the planning board anyway for an amendment, and also which is reflected in the construction loan, which would say request a completion date amendment from the Saco planning board. So from city staff perspective, we would be in front anyway. Next steps, whether this is approved or not approved, is something we haven't really discussed into option A or option B, what will happen. But I know that with the condition of approval timing, we discussed this at one of the application completeness hearings about, was this a timely request? Was it in before that date? So these are all conversations that we've kind of loosely had at the planning board, I would say, but it would really bring us to the planning board talking about this condition of approval, which is reflected in the construction loan agreement, and it would be our first step in compliance.
Okay, did I miss in that construction loan agreement where there was a condition or a requirement that the board did grant an updated condition or an extension?
Yeah, it was in what Member Brochu was referring to, that second paragraph of number 6. And I'll just read the that full section. Should the project be delayed during construction for any reason outside the control of TES, the city covenants it will reconsider and abate enforcement of the current October 2025 completion date if necessary, or request a completion date amendment from the Saco Planning Board. Goes on, but I'll just end it there. So the last piece of that sentence is, or go to the planning board.
that doesn't stop the project from moving forward or from the construction, right? Does that sort of, I know it's a,
Yeah, we're kind of getting
I know
into
it's
that more
difficult here.
legal side of
Sure.
contract law, so I'm not going to weigh in on I'm not an attorney, so I'm not going to get it. If you have, more legal questions about that, we can get legal advice for the planning board, legal guidance. I don't, they're all related. I wouldn't say they're separate. But again, just to focus the planning board, we are talking about here the condition of approval. Don't have an answer tonight for you. If you guys vote it down, would that stop the project? But the applicant spoke to what he believes would happen, and we can, follow up with that if you would like.
okay, thank you. So I guess where I'm going with this, or the reasons I'm asking these questions, is similar to Jeff's questions and thoughts here. So there's, as Jeff had mentioned, we've had a few amendments here for the project, and I don't have any information in this application before me. I'm trying to, there's a lot in here, so I'm trying to simplify a little bit, that guarantees completion on that date. So we made a few amendments, the date's changed a bunch. So that's what I'm trying to create resolution on, or trying to understand. So that's where I'm going with these questions here. So, okay. Any other questions from board members? Joyce?
Well, yeah, I mean, I read this paragraph to imply that the city understands there might be delays. I mean, it really is, it's only talking about outside the control of TES, but if the project's delayed for reasons outside the control of TES, the city is saying, we're not going to hold you to it, we're not going to punish you if this is completed late. It doesn't say anything about what happens if it is delayed for reasons outside the control of TES, but, the implication is the city is not holding an absolute strict deadline because they understand things happen and sometimes construction projects are delayed.
Yeah, thank you, Joyce. I agree. For lack of a better term, it's still hopes and dreams.
Yeah, a
right
little
now.
loose. And the
I
other
don't-
thing about oh, sorry, just
Nope, that's
one more.
fine, I'm done.
Just a general comment, and you're probably going to talk about this anyways. There are plenty of pieces of property that have more than one mortgage. So the fact that the city has a second mortgage, I hope that the city did a title search before they agreed to a mortgage and that the city was aware they were in second position. It's the first mortgage would be of public record in the registry of deeds. It was there to be seen. So, certainly I don't think there's any implication that the ecology school somehow hid the fact that they had a mortgage on the property, because it would be impossible for them to do so.
I understand. Catherine?
Echoing Jeff, I do have questions about whether or not, as a board, we can hear it or if it should go back to city council. But I did also want to follow up with the applicant because he said he was happy to explain, and I had read it the same way that Jeff did, that city council had to step in and pay for the outstanding invoice, because it does look like it was more than 120 days late, and they were trying to get the plans. So the applicant had said that he'd be happy to explain that, so I was hoping for more information on that.
Sure, yeah, I think I'd like to have the applicant comment on a few things. I know there's, just generally speaking, I know there's a lot of dates and it's hard to follow in there. I'm still looking at the big picture. I'm trying to look at the big picture here. So as far as the timeline of that design and who paid who and when, that still doesn't tell me, none of that tells me that it's going to be built by the deadline, by the date that's being requested. And
Absolutely.
that for right, and I say this because along with Joyce, we've been fortunate enough to been following along with the project in its entirety. So I'm just looking for reassurance. To Jeff's point, we've made a few amendments here that I think have been reasonable. I think the applicant had made some efforts. So I'm looking for something concrete. That's all. So if the board members don't have any other thoughts, back to the applicant for thoughts, comments, back to any of the board discussion.
Excuse me. Sorry about that. Thank you. There's a few things floating around, and I'll try to clear up a couple. First, I've kind of, I don't know, hit this nail once or twice before in this space, but as a reminder to the board, the wording of the condition is and always has been that the applicant will work with the city and MDOT concerning the turn lane, because there could never be an order that the applicant build it. That's not actually what the requirement is. The requirement is not for us to complete that turn lane. The requirement is to work with other parties who will then complete that turn lane. So the applicant's position is, we've done that a lot. There's been a lot of working with, but the actual construction part that I think you're focused on, in terms of how the city and MDOT know that this will be done by June of 2027, that's outside of our control and always has been. So that's, I think, one point of clarification. As to the payment sequence, it's interesting, and I want to be mindful of this. I think there's a council representative here who probably has a better memory on this than I do, but I know the council was represented in the loan document process. I'm sure that they were advised on it. And I do, and I've had several conversations with the council's attorney. She's excellent. The council is well advised and knows what its rights are. They're not without advice or opinion. They have plenty of access to that. The applicant has received no default notices of any kind. Not even a threat of those has happened. So simply observing that there may be some condition that you don't understand does not create a default that we can respond to. That's sort of like asking a question. Does not create a circumstance that the applicant then has to marshal a sort of default analysis defense to. We've received no notice of default. The city knows what a default is. The city council has a lawyer. That lawyer has never once used that word in any conversation I've had with her. There's no default position that the applicant can therefore respond to. And so to sort of preemptively ward off theoretical defaults is a somewhat frivolous exercise. That's a parlor game, right? That doesn't go anywhere. That's very hypothetical. So if there were an actual default concerning the merits of the mortgage, the applicant's compliance with any documents that the city council has signed with the applicant, the only source of information I could reasonably respond to would be the council and its attorney, which has said absolutely nothing concerning these matters. So I just want to be clear, I'm not here to chase ghosts of defaults. That doesn't make a lot of sense. If there is a default, we can respond to it and would. There is not. There is no response, therefore, for that. As to the payment process, this is something I discussed, and I think it's fair to say, areas of sort of disagreement, perhaps, between the applicant and the city in terms of how the Sebago Technics funding was handled. And what I think, from the applicant's perspective, I can ask for an understanding on, is that the account was partially funded. It was partially funded substantially and in an amount that was sufficient to pay the Sebago invoices. And the city was holding on to the funds in a deposit account, a sort of set aside for this project. And the question became, could any disbursements be made from that account prior to its being fully funded? Could a disbursement be made when the account is partially funded? So the invoices that were presented could have been covered by the funds on account. The city took a position, no, we think you should go get that money and fully fund the account before any payments are made from it. The applicant took the position, I took the position with the city and its council. That doesn't make a lot of sense to me. The money's sitting there. We're going to get sued by Sebago eventually, and I would be forced to name the city as a contributing party in that litigation if Sebago sues me because they're holding funds that could be used to pay this. Various scenarios there become somewhat interesting where the city could take certain actions to make consequences for the applicant under its permits, land use code, things like that, it could have issued a default under the loan documents. It didn't. It reached a kind of détente where the city did not make a move to enforce the documents. The applicant did not make a move to pursue the claim that I just described, where the city was arguably holding on to some funds for reason A that didn't defend it from reason B. But the sequence of payments was a sort of unfortunate series of events, I guess, but I don't think that the city became a creditor of the ecology school in that dimension. The funds that were on account were always sufficient to pay Sebago and have since been fully funded to the point where the city did release the payment to Sebago, and Sebago was relatively cool and eventually waited for that payment. So that's, I think, what happened. Now, to be clear, the city is a creditor of the ecology school under the mortgage documents. So I'm not saying that the city is no kind of creditor to the ecology school. It is under those structured payments. And if and when those funds become needed for disbursements for project expenses, the city will disperse funds from whatever account it has those in, and those will be slowly replenished through the mortgage payback over time and terms. So the city is in a sort of future iteration of this. The city will become a creditor of the ecology school, and there will be payments made that the ecology school will be obligated to repay through the mortgage. But that's not what happened with Sebago Technics, to my understanding. That was, again, a robust debate where I think both sides kind of reached an accommodation that allowed us to sort of proceed with the project for reasons of, agreement and comity, I think, to try and keep things moving forward and not have a dispute between the parties.
All right, thank you. Jeff, you have thoughts? I just want to, well, go ahead. I just want to say again, as far as the monies and the payments, don't answer a question here and don't provide an answer or any evidence or reassurance that the date can be upheld here. All these the past monies and who's paid how and when, and that's not what's before us here. It's can we amend condition 9 to change the date, which again we said, as you noted, Mr. Van Hamel, that the applicant will work with the city and DOT, as you said, to design and construct. I want to make sure that piece is in there, and construct the left lane. So it's not, get the ball rolling, but it's to completion, construct. So that's what we're looking for here. I just want to go back to that's what we're looking at. So with that, any other questions from board members? Jeff, go ahead.
Thank you, Mr. Chair. I'm just always perplexed at the spin on words. And, I was involved in that, the applicant shall work with the MDOT, and we get it. That was kind of boilerplate terminology I think we used on multiple off-site like infrastructure, and maybe the wording wasn't ideal, but boy, we're really having to spell it out. And I feel like the city did a fantastic job when they did the loan agreement on May 24th, 2024. They really spelled it out for the applicant. This is what we're going to expect you to do. And number 5 was the costs and management of the project. TES shall bear all engineering, design, and construction costs for the entire project, less those costs paid by the BPI grant. Okay? Once the design is approved, the city shall manage. Number 6, TES shall provide the city with an anticipated design within 30 days of receipt of this agreement. In my professional world, shall is a very directive word. There's no other alternative. And they didn't pay for the design until the whole project was supposed to be completed. So I don't see why we should be extending it. There is complete control of delay on the applicant's part. The reason that the city's where it is because they didn't hold up their end of what they agreed to post all the amendments with the construction agreement with the city. The city spelled it out. We shouldn't be looking at the city saying, well, you're part of the reason it's late. You didn't get easements. You didn't get that. They didn't have what the applicant agreed to again on May 24th, 2024. So let's just say the applicant did not hold up their end, choose not to grant an extension because of those facts that they did not fulfill. I mean, this is a pretty golden sweet deal that the city worked out. I mean, city doesn't reach out to a lot of applicants to offer this type of additional help and assistance. All the applicants that are before us for these off-site improvements, they're paying their engineering firm and construction firm. They manage it all with oversight from DPW. I mean, the city's going to general contract this for them. There's a lot here, and even with those gracious leads from the city staff and team, they managed to delay it again. I don't think we need to grant another extension. Thank you.
Thank you, Jeff. Any other, Jim?
Mr. Chair, I was just wondering, this is also scheduled as a public hearing, I believe. And when it's appropriate, Mr. Chair, I'll move to open the public hearing.
I would second that.
All right, thank you for the motion, Jim, and the second, Jeff. Any additional discussion on opening the public hearing for this item? All right, those in favor. Chris?
Yes.
Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 6-0 to open the public hearing on this item. If anyone is, thank you. If anyone is with us this evening to speak on this item, please come to the podium and state your name and address for the record. As a reminder, this is a public hearing for an amendment to a condition of approval 9. So this is limited to planning board items of review, not zoning or the like. But if anyone's here this evening, please come to the podium and state your name and address for the record.
Hello, everyone. I'm Kelly Archer, 185 Bradley Street. There's a lot to unpack here. I understand it is condition number 9, and it's an extension. However, there's so many layers to this particular request to the planning board that it opened up those layers, and that would include the MDOT BPI, the CLA construction loan agreement, and then the mortgage and the promissory note is also tied into this. So I cannot filter just staying on an extension. There's contract zones that are involved with this one, and it has a site plan approval in 2018. First and foremost, I'm going to start off that, one, you shouldn't even be hearing this. There are so many breach of contracts, breach of agreements that is so heavy that why didn't staff bring it to when they knew that construction loan agreement and they've been working, and we had a letter from the former city administrator, 38 pages, to the council. Why didn't it go to the council saying we have an agreement with TES on a BPI with MDOT? Why didn't it get to council on the floor? Why did it get expired? Where is staff protecting that CLA? Before October 2025. It didn't even have a date on it. I have an issue with that. Put a date, October 15th, 2025. It just says October 2025. The payment, I'm going to jump around because so much here. The payment, that last payment, that was done on December 3rd. If you read the terms of the BPI of 6/3, that was the executed date. Even though they did it in May 24th, the last person that signed, that's when it becomes a contract. That was 6/3. So your timetables on a contract goes off of 6/3. And so when you go 18 months, and it says within 18 months, exact words matter, details matter. These are contracts that people sign. Know what you sign. And when you go within 18 months, that should have been done by December 3rd. The CLA at the same time said have it done by October 2025. So and then that we had one with the amendment with the contract, with the site plan, it said November 1st. Everybody knows, should know, and then it gets to you. And it shouldn't be here. It should have been at council. They are the ones that it went out of contract. And then that last second payment made on December 3rd. Why is staff, why are the attorneys, why are the easements still going on? Why is the time here? It is expired. It is null and void. We've already gone, citizens have already gone to the Supreme Court. Null and void is null and void. Stop this. If it's expired, if it's breached, if it's null and void, that's your answer. Supreme Court said it in Dahlem versus City of Saco. But here we are, we keep doing these extensions, we keep doing these approvals. So to cut to the chase on the CZA and the 2018 site plan approval, it is, the real inflection point here is that the CZA and site plan are null and void by their own terms. That's part of the 400 pages I've given you. Read those by its own terms. Both the 2018 and both the CZA are null and void by their own terms, and TES has in over 8 years not even started construction of the left turn in furtherance of condition number 9. TES is out of compliance, and this is an enforcement issue for the CEO and the city council, not you. It is not an actionable item before the planning board. Now, let's go to, I will quickly just do this if I may. I am here to speak on the critical necessity of accountability and compliance. This is not a routine, simple extension request. We are looking at 8 years of compounding issues and non-performance. The board has referenced legal counsel's advice, yet that opinion is not in writing before you or the public. Making a decision of this magnitude based on verbal summaries, essentially hearsay, is a failure of due diligence. Before any vote is taken, the city must produce the outside counsel's written legal opinion for the record. Legal counsel should put their professional license on the line in writing concerning the contract zone and the site plan agreement before this board risks the city's standing. The evidence is overwhelming. The applicant has failed to satisfy condition number 9 for 8 years. Furthermore, the application now involves a breached and expired city loan agreement introduced last meeting and now in that tonight's packet, which was the canceled meeting, complete with a mortgage and promissory note. The city must stop acting as the applicant's line of credit. We are not their bank. The reality, this is a track record of non-compliance. Why is the burden of accountability being shifted onto the citizens of Saco rather than the applicant's leadership? What is really going on? The burden is on the applicant, not the citizens. By failing to enforce state statutes and city ordinances, the board, council, and staff is effectively inviting a lawsuit from its own citizens. This has got to stop. You know I'm talking on other contract zones too. It's an easy look. If I can do it as a layperson, lawyers can do it. In my opinion, why is the City Council Planning Board putting the citizens of Saco in a position to have to sue the city to force compliance with laws? In my opinion, the city's current risk management strategy appears to be one of conveyance over compliance. Keep the applicants happy and assume that aggrieved citizens lack the resources or the will to sue. Your duty, your oath is the law and the citizens, not the applicant. If the application is weak, which it is, and the conditions have been breached, which they have, the only lawful path is to deny the application. If the applicant feels this is unjust, let them challenge that denial in court. Do not put the citizens in the position of having to sue their own city to ensure the law is followed, or have us pay for this egregious 8 years of this left-hand turn lane. Force the applicant to prove their case in court. Citizens will move this beyond the planning board to state officials and the attorney general to investigate why our local officials refuse to follow local and state law and contract law and agreements, and the systemic failure of accountability regarding these city-backed loans and non-performed conditions. This cycle of non-compliance has to stop. Put the accountability where it belongs. Hold the applicant accountable for their own failure to perform and deny this request. I repeat, do your duty, follow the law, deny the application, and let Tess go to court to challenge this denial of an extension. Please, this is bigger than you think, and it will be disclosed to you. Thank you.
Thank you.
I'm going to take a big breath. Good evening. I'm Inga Brown, and I live at 161 Simpson Road. I certainly don't want to point my finger at you, board, but I think that your homework completion was maybe not as thorough as it should have been. You should be familiar with the contract loan agreement. There are some very elementary, basic level questions that, forgive me, show a lack of grasp of some basic deadlines and some of the history on the project. I would like to provide some factual dates and records for you. The construction loan agreement was signed on May 14th, 2024. I have that in writing from City Administrator Bohenko, from Pat Fox. May 14th, 2024. The construction loan agreement, and forgive me, but I do believe that board members did not quote from it appropriately, so I will do that for you. I'm reading from the construction loan agreement. This is item 6, and I will read it. Project timeline. All project work shall be completed by October 25, except any landscaping if necessary that must be planted in spring. TES shall provide the city with an anticipated design and construction timeline within 30 days of executing this agreement that will achieve meeting the October 2025 timeline. Should the project be delayed during construction, October 2025, the project should be completed. The delay is only if there is delay during the construction process. So you please need to go back and read the contract. If you are not comfortable dealing with a breached contract, then I highly suggest you table this item and send it back to the council. I presented to council last night. I put into the record the BPI, the CLA, and the breached dates. What was the CLA about? It was a loan of $308,233. The ecology school, a year after signing this agreement, had not paid the city the full amount of $308,233. The city sent a memo, and I must say this, I appreciate staff's very hard work in putting the after-the-fact packet together. Thank you, staff. There are no page numbers. This packet is unwieldy. I can't even tell you what page to go to. There are no page numbers. It's true, I submitted several items. I can't refer you to the page, but I don't know what to tell you. This is not a user-friendly packet. It needs page numbers, however that can be done. So I'll do my best. In the packet, I submitted a council memorandum. Go on and grab it. It is in your after-the-fact packet, everyone. This is a memorandum written by the city to the council. This was written on May 30th. Please note, this memorandum was written 1 year after the construction loan agreement was signed. We're talking about May 2025. The memo is uncomfortable. The ecology school has not paid the city for the full amount of the construction loan agreement, the $308,233. I will quote from the memo. The left-hand turn project is on hold because the ecology school has not paid Sebago Technics. As a result of not paying Sebago Technics, final engineering plans, including final temporary and permanent easements from abutting property owners, have not been received. Therefore, the city cannot move forward with bidding, or with acquiring necessary easements to complete the project. The ecology school is skirting and repelling its responsibility to the city of Saco. I am tired of entities who are partners with the city. They take no responsibility for their lack of payment, and they are pointing their fingers directly at council and staff. The delays are because council and staff. I have never heard a more repugnant defense. There are so many layers of discrepancies, and you have contracts that are in breach. I am going to correct the record. Mr. Van Hemel, you stated at the beginning of your comments that there is a traffic study that must have been approved by the city, we didn't hear anything, by Sebago Technics. That is false. The ecology school paid Sebago Technics for a traffic study. And lo and behold, that traffic study was not reviewed by city staff or by any third-party reviewer. It is a paid-for, by the ecology school, traffic study. That traffic study showed maybe the turn lane should be built by the city because all the traffic out there, the ecology school shouldn't pay for it. This is the beating of the drum. This condition of approval is not our responsibility. This is not our responsibility, city. This is a condition of approval. It is lapsed. If you will read the packet, there is a sunset clause in the contract zone agreement. The contract zone agreement is in your purview. It is in some of your packets as a previous approval. The contract zone has a 2-year sunset clause. The ecology school in 2018, please follow me on this if you could, they received conditional site plan approval. It's conditional. That's why they're back here asking for permission. They only have conditional. They never requested an extension on their contract zone. The contract zone, if you read it, is null and void by its own terms. The layers of legal discrepancy, it is not your purview as the planning board. This must go to council. You need to table this, or you need to figure out if you're going to deny this extension. I am tired of entities coming to this board and changing the narrative. It is a mischaracterization. It is pointing at the city. And who has not paid their bills? All along until December, when this process began on November 4th, you had a completeness review hearing. Their bills were not paid at that time. What have you done for me lately? This entire process is incomplete, it is non-compliant, and I urge you to read the construction loan agreement, to read the BPI. There are no contract extensions in any of your packets. It is Contract Law 101. It is inexcusable how messy, how incomplete this process has been. And I apologize, but it is frustrating. I will leave it there. I hope this public hearing will remain open. It is very difficult when misstatements and non-factual items are stated at the podium. And members of the public have to take their public testimony time, thank you for this time, correcting the record. I don't want to correct the record. I want to come and talk about, as a citizen, as an abutter to this project, what I'm concerned about. The factual record should be clear. Everyone should understand if these contracts are legal, if the dates have not been breached. It's like we're trying to build a house. We haven't even bought the property yet. You are working in a dysfunctional process. As far as the continued beating of the drum of citizens coming to this podium and speaking with ill words and low character of the applicant, we have talked about the factual record. I am not interested in pointing fingers, of talking about someone's character that has nothing to do with this process. It is about the documentation. Please leave the public hearing open. I'm sure there will be other things to correct. And if you can't get the answers from staff, and if the applicant can't provide them, then table it till you have the information that you need. You cannot work with a broken process. Thank you.
Thank you.
important part for it. What we can do is get this going for you.
Good evening. My name is Deb Hilton. I'm 143 Simpson Road, and for the record, I'm a CPA with over 35 years of experience. I want to refresh your memory on what we talked about on December 16th. You'll recall that we talked about the audited financial statements. I went through 5 years' worth of audited financial statements that were done by Baker Newman Noyes and another accounting firm. In 2023 and 2024, they received a going concern opinion, which means there's substantial doubt about the entity's ability to continue to operate. We talked about a default on their $8.6 million USDA loan. We talked about $900,000 of loans that are coming due in April to June of 2026. You've heard them say their dire financial situation right now. They can't even afford to pay bills. They're anxious to get the cash back. I also want to remind you that there were 5 areas that caused this going concern opinion and gave the substantial doubt about their ability to continue. Ongoing operating losses, 3 of the last 5 years. On the slide in front of me, the first column shows $245,000 loss in 2022, $818,000 in 2023, and $1.1 million in 2024. They had $1,270,000 of equity. Net assets equals equity for a nonprofit. You look at the trajectory of those losses for the last 3 years, you can easily eat away at your equity. If that happens, you become balance sheet insolvent. That is a very high likelihood that after 2025, they are balance sheet insolvent. They are cash insolvent. They can't pay their bills more than a year. They took out a loan. They tried to take a loan out from Quimby for the $75,000 so that they could pay the extra $68,000 into the project deposit account. The city declined that intercreditor agreement because we would be put third in line. So the $250,000 that or the $500,000 that was already owned on the property, they had a mortgage between Quimby and Sewell for $500,000. We were then on there for whatever's left. Well, Quimby and Sewell were like, we don't want the city of Saco in there. We want to be there for the next $75,000. So that's how even their creditors, people they've worked with for 10 years, are protecting their interest. And I am glad that our city council met on it and decided not to sign that intercreditor agreement. It would have been a bad deal for Saco. They then went to the USDA. The USDA would not give them an additional loan. They tried to get a re-advance while the loan was closed. The only other type of loan they could get would be a protective loan, which basically protects the property for the creditors. So when you're looking at a financial situation like this, when you have an insolvent player, what we're really dealing with is protecting the value of the property. And that's what I believe they're trying to do. So in order to protect the value of the property, you need to make sure, and the USDA does this, it's right in their guidelines, you need to come clean with all of your conditions of approval. All your code violations need to be cleaned. And that's because if they have to foreclose on the property and sell it, they don't want those conditions of approval or those code violations following them. So I'll go back to 3 years of ongoing operating losses, negative cash flows, 4 of the last 5 years. Look at the negative cash flows, 1.7 million in 2022, almost $1 million in 2023, 1.2 million in 2024. They financed everything. They were able to stay afloat because of increased financing. They don't have that ability anymore. If they're balance sheet insolvent, there's no way to get extra money. There's also a stoppage on Federal grants. You've heard Drew talk about this. He's put it in writing. It's very difficult to get federal grants right now because of everything that's going on with the Trump administration. Those grants are not going to be coming forward. They're going to continue to have problems getting cash. And that means their existence, their very existence, is on the line. Debt levels, $12.5 million. They're more than 10 times their equity as of 2024. Now, there's likely no equity. Why is this all important? Well, we have 9 properties on Route 112 where people are at stake of losing some of their land. Eminent domain cannot proceed if you have an insolvent entity that is drawing this need. So, under the main eminent domain law, the taking is only lawful if there is a public use and a public benefit. The school's going concern gives you substantial doubt about the school's ability to continue. Without the school operating, there's no need for the turn lane. So the taking of private land would really only support a higher resale value for creditors. And that, again, is what I think is happening here. There's been 7 years, and they are in the worst financial condition they've ever been in. Insolvency, almost. And I won't say absolute, because I haven't seen the 2025 financials, but I feel pretty comfortable saying that's where they are. They can't even pay their bills. So the public benefit, again, must be current. It cannot be speculative, and it cannot be a potential future benefit. It is speculative with an entity who has received 2 going concern opinions that have substantial doubt about their ability to continue. So you are risking the city of Saco having a legal challenge as a result of an improper taking. So this is not just a date extension. It's been 7 years of delays, all because of tests. So this impacts citizen of Saco taxpayer or property rights. These are the 9 properties on Route 112 that are impacted. The yellow line is Route 112, the green is the Simpson Road. You've got 9 properties that are impacted by this turn lane, based on Saco Technic's review. These are the 10 properties in total that are impacted, 9 of them, again, with a permanent easement. There are 10 that have a temporary easement. This, by the way, is completely different than the conceptual estimate. I sent something over the weekend. I don't know if anyone's had time to look at it, but the conceptual estimate that came back with $924,000 estimate for the project cost was based on 1 permanent easement, not 9. It was based on 3 temporary easements, not 10. It was based on 4 utility poles being moved, not 6. Saco Technics did a much more thorough job. Of course, their engineering plans, which, by the way, are still not complete. They're 90% complete. So I would argue, what I sent over the weekend was support for the fact that the $924,000, of which they did their 1/3 project deposit account of $308,000, is completely wrong. It does not even have the same scope. So if you're looking at 4 poles instead of 6 poles for utility pole movements, you're looking at significantly longer distance of road. So a pole is usually 125 to 150 feet apart. So if you're talking 2 poles, 2 extra poles, you're talking 250 to 300 feet of additional road construction. So that $924,000 is meaningless. The easements alone, and I'll go ahead a little bit, and I'll jump ahead to what I sent you over the weekend. Hopefully you can see this. The blue is the conceptual plan. They said they were going to spend $20,000 on that 1 permanent maintenance easement. Saco Technics said, no, it's going to be $180 because you have 9 easements. The temporary easements, they said, oh, there's only 3. Well, no, Saco Technics looked at it further and said there's 10, so that's $50,000. The utility poles, they have an estimate of $10,000 per pole, which is completely low. When I was at the utility, it was $25,000 a pole. But I didn't change that on here. So 4 poles is $40,000. However, Sebago Technics is 6 poles, so I said $60,000, the difference of $215,000. If you go back and you add that to this estimate right here, the 924 plus the 160 plus the 35 plus the 20, you get to 1,000,001. I then adjusted it for 2 years of inflation, which you have to do. To determine the financial capacity of this entity, you have to adjust for a new forecast, a new project estimate. So you're close to 1.4 million, and that does not even include the additional road, which I'm not even going to guess at. But that's got to be substantial if you're talking 250 to 300 feet. So they are trying to get by with this lowball estimate of 924,000 because they could barely scrape by to get the 308. The way they got the 308 is they took the letter of credit from what they originally had when they built the property. We all need a letter of credit, right, to be able to go back and make sure they clean everything up and they do final landscaping and everything. They came to the city and said, give us the letter of credit. We can get money that way, and then we can start paying our engineering bills. So that's what the city released, was the letter of credit. We don't release that on anyone else, but that was another exception for them. They then had to come up with $68,000. And again, they went to their 10-year partner, Quimby and Sewell, who basically said, we're not going to give it to you because you have too much collateral on that property. They then went to the USDA. So in order to even pay for their project deposit account, which is severely underfunded, because again, the road construction is going to be significant, far more than this $924,000, which is an estimate from 28 months ago. You need a new estimate. And you know what's funny is the progression of cost for this left turn lane. It started off at $300,000 back in 2019. It then went up to $640,000 in 2020. It then went up to $924,000 in 2023, September of 2023. Now, don't you think if you were doing this estimate, or if you were doing this project, the technical capacity of this would mean you get an updated estimate? They chose not to do it because they could barely make the 308. This is an insolvent company that cannot pay their bills, okay? So it's unacceptable from a technical capacity standpoint. It's unacceptable from a financial capacity standpoint. So the BPI funding. The BPI funding was a 36-month contract. And they said, you have to have a construction start deadline of December 3rd. Well, they went 20 months just messing around with trying to get the engineering plans. They couldn't pay for them, so it dragged out 20 months. There's only 16 months left. And you know what they did? Sebago Technics said to them, well, you missed that first deadline. And yeah, we put something in writing to you that said we're not going to be hawkish on the date, but that is not legally binding. It's not legally binding because you need an amendment in order to make it a legally binding document. That's an email from somebody at MDOT that said, don't worry about it. But then in another email, he said, you got to be careful because if you miss anything else, the city may risk the $308,000, and you may have to pay it yourself. They didn't tell you that, did they? That's in one of the emails as well. So the bottom line is this will be a burden to the Saco taxpayers. One way or another, it absolutely will. The other thing is the construction loan agreement has a 0% interest rate. If you take an amortization schedule, which I have done, and you take those payments that they're supposed to make, $7,500 for the first 10 years, and then like 20 grand for the next 10 years, that equates to, over that 20-year period of time, $245,000. So we're basically paying for it anyway. And the thing is, it's going to be way more than $308,000. Their share on this is going to be more than $308,000. So they've got the 308 out there now, and they're paying some engineering bills from it. This loan for 308 is going to be substantially more because all of the overruns go through the construction loan. Saco pays for it and tries to collect from an insolvent entity. How sweet is that for them? The Saco taxpayers are going to pay for this. We do not need a turn lane. I've lived there for 30 years. We've never needed a turn lane. The turn lane is a result of the ecology school. They can pay for their own traffic study, but the bottom line is they're paying for an answer that they want to hear. So you really, if you are on the fence at all about this, you got to table it. This is the most ridiculous thing in terms of, I'm very surprised that we're going back and forth still on some of the contracts. Why are we even, discussing this? We shouldn't be discussing it. It should be an absolute no. 7 years, they already had 2 extensions. In the code, it says you're allowed 2 extensions. It doesn't say you're allowed 3. The other thing is, in the last extension, it said it must be done by November 2025. They missed that date. The only reason they want this is to ensure that the creditors can get as much as they can for the property. Or whoever buys this place has something set up and all they got to do is go along with the 0% interest rate loan that the city of Saco gave them and the BPI money. So, I think I've touched on everything. Thank you for your time.
Thank you.
Can you return the click share to the dais? Just, sorry, no. It's going to be frozen for a second, so yeah, there we go. Fine.
All right, not seeing anyone coming to the podium here for a moment. Back to the board. Any thoughts, questions, or concerns for the moment based on some of the public comment we received? Jim?
Mr. Chair, certainly there are a number of concerns that residents have raised about this application. I think with respect to the issue of whether or not the application to extend the deadline was filed timely, I think we concluded that it was. With regard to financial and technical capacity, I don't think that that's really an issue for us with respect to this application. That finding was made when the site plan was initially approved, but I don't think, at least my read of 179.3.01F, I don't think it brings back that same financial technical capacity issue that the planning board initially had to address. So I don't see much of that public testimony or information provided by the applicant is particularly helpful. I mean, we know that the $308,000 account was funded. We know that, albeit late, but it was funded according to the documents between the city and the applicant, the construction loan agreement, and the other documents. Those financial obligations of the ecology school have been met. I understand there's a lot of concern about contracts having been breached and so forth, but I see that more of a council issue. It's really not our issue. The council entered into that construction loan agreement. They took, I don't know, a second or third mortgage on the property. I'm sure that they knew it was a second or third mortgage because their attorneys would have done a title search, as Joyce pointed out. So I think that to the extent that there are concerns about this left turn lane or any of the costs associated with it, I think that's really a council matter. So from my perspective, Mr. Chair, and with the voluminous information we've received from both the applicant and the staff and the public, I feel like I've read the same documents 2 or 3 times now. So I don't think there's any, I cannot imagine a reason to keep the public hearing open. And so when it's appropriate, Mr. Chair, I'll move that we close the public hearing.
Thank you, Jim. Any other thoughts, questions, or concerns from board members?
I'd be more inclined to get applicant response to public comment and then see if there's any additional public comment after that before closing the public hearing, personally.
Any other thoughts from board members?
I'm not opposed to that, Mr. Chair.
I think letting the applicant respond to some of the public comment is fine. I still want to focus on the matter at hand here. It's the condition. It's extending the condition. We have thousands of pages before us that we have read. So I just want to make sure that that's clear, that that's the understanding. So if the applicant would like to come up and respond or make any comments to any of the public comment, please do so. Again, we're looking for the evidence and clarity for the amendment to the condition as part of the site plan approval here before us. So with that, go ahead.
Thank you. I think many of the comments you heard are in that category where I sort of said it's difficult to kind of chase ghosts and respond to things that are kind of too far afield or not particularly material. I think Member Mahler has kind of identified the actual standards that apply. The Ecology School is fundamentally it's a nonprofit organization, and so it gets income from a number of sources. It can have donations. I've worked with it to accept bequests from estates. Those types of funding are unpredictable. You don't know when somebody dies and leaves the school money. Could be in Councilor Brochu's will that he leaves them $1 million. We don't know. And so, and so there's a certain unpredictability in terms of trying to snapshot the Ecology School's finances. A lot of the allegations in terms of things like, I frankly don't follow the contract zone stuff. I'm not prepared to present on that, or theories that the Ecology School is going to sell its assets or do, like, I don't even know where to begin on those kind of things. But what I can say is the Ecology School has prepared its materials around the numbers that are actually in the requirements, the project requirements. And so to call for a response to theoretical putative numbers that are not in the project file is very challenging. And that's where I get to, you know, if my neighbor writes me a speeding ticket, I can't go to court to contest it, nor would I pay it. And so what I'm left to deal with on behalf of the applicant is the actual numbers that we're supposed to satisfy are set in the project. They're not manufactured in this hearing to a different standard that I then have to respond to. They've been met, as have the technical specifications. The ones that are actually set forth for us to satisfy have been satisfied. To sort of reset those expectations via public comment is not something that gets a quality response or a quality outcome. So the ecology school has not received any notices of default. The ecology school has provided evidence of its abilities financially and technically to perform this project on the numbers that are actually on the pieces of paper before it. And that, I think, is the extent of the review or the presentation that we're prepared to make. And so I don't want to leave some of the comments with the appearance that they're unanswered, but it's kind of a ghost chase again, you know, to sort of respond point by point to some of the allegations or suggestions or analyses or spreadsheets as to highly conjectural things that are not in the project's requirements is very difficult and seemingly immaterial to the board's review. So I would ask the board to constrain its review to the actual numbers that are in the documents, the project documents, and to the facts that the ecology school has made the payments. Again, I think the case has been made that they were not as early as you know, would have initially been ideal, but they've been made. The city's funding is solid. The MDOT funding is solid. There's a year and a half to build the turn lane. That's in the city's hands. The engineering has been completed. The procurement of easements is another item that's in the city's hands. And so that's where I think the focus can be. And it simplifies quite a bit the task before the planning board. I do have, if helpful, I think the ecology school's business manager is available to answer some of the concerns about the long-term vitality of the school or something like that. But this is outside of the planning board's standards anyway. If the city council has a concern about the ability to repay, they have not communicated that to me in any way. Nothing. Absolutely nothing. And so that is the source from which I would need to take that cue. And to raise that concern on its behalf by a sort of public proxy is not something that gets a response. It doesn't work that way. That's what I said, like, that's my neighbor writing me a speeding ticket. I can't go into court and say, Your Honor, I was following the speed limit. The court says, what are you doing here? Right? There's no official process for the court to get involved with. So I think that the materials that actually answer the actual questions have been fully and amply presented to the planning board within the scope of the factors that the planning board is called upon to review. And unless and until I receive default notices or enforcements, actions or something, none of which have been received, no notices of default, no enforcement actions, nothing. I don't think it's fair to ask the applicant to respond to those things because they don't exist. The idea of them may be existing under certain circumstances that you suppose or project into existence, and calling for a response is way off the mark. I'm only able to respond to those things which come through official channels, and they have not come through any channels. The parties to those documents have not alleged any of these defaults, any of these concerns. And so am I going to respond to theoretical defaults from parties that don't hold default notice rights? I don't think so. I don't think that's what the planning board is called upon to do. I don't think that's what the applicant is called upon to do. So I think that's the best way that I can respond to that is that discussion, certainly I recognize Saco has a robust, public forum for debate, and plenty of information is available, but the information which is material is not the same as the information which is available. The information which is material is a subset of what you've heard, and I think that the material information supports the extension. I also come back to, there is a, I don't want to set policy for the city of Saco. If this condition or the left turn lane is not something that the city of Saco wants, that came from the planning board. If the planning board wants to vacate that, the college school has absolutely no objection to vacating the left turn lane. It would be great if we didn't have to do this at all. You're welcome to drop that requirement, modify our project permits. We would do that in a heartbeat. The idea of the city, or I'm sorry, the ecology school, paying for traffic studies, because you made us, right? We were obligated to pay for those studies. That's not something where we manufactured a result for a traffic study. Sebago Technics isn't selling itself out on its professional licenses for the ecology school's, fees. These are things that I think there is space for the city council to make policy. I don't know, quite what the planning board's place to make policy is, but if there is some consensus on the planning board's part that the left turn lane is no longer called for or desirable, hooray, give us the money back, cancel the obligation. That would be great. But since we're stuck with it, we've been doing our best to respond. And, despite headwinds and a financial climate that we've been forced to function in, the city has not declared any defaults. The city has observed that deadlines have been flexible. The city is engaged in negotiations and responses that we've done our best to keep pace with and keep this project afloat. But if the modification is something that the planning board wishes to relax, have at it. Until that time, we're sticking with the application that was submitted. We think it's been fully documented and papered. And the rest of it is again, sort of off the mark. That's the response I can offer. Thank you.
Thank you. Board members, any questions, further comments or concerns for the applicant while we have the public hearing still open? Thoughts from board members on how you'd like to proceed? Jeff?
Thank you, Mr. Chair. I mean, obviously, a bounty of information provided tonight, and I'm trying to keep my review very tight to, as the applicant's talking, to this request for an extension. And I feel like part of that review is the construction loan agreement that they started. That's their last stage for their second extension to get this goal built. That was kind of an agreement, lifeline, that the city put out there. There were terms within that for timeline so that the city would be willing to go out and do the business partnership initiative with the DOT. And granted, the inflation might be there, but we're looking at a fixed number that was in that agreement. And the city has said that they would back the ecology school for that amount. There's an agreement in place with a payback policy. Whether it be sound or not is not up for my view on this board to look at. But I do feel like because of the timelines in the BPI and the timelines in the construction loan agreement, that timeline needs to be reviewed. And that delay of the 20-plus months or the year that they did not pay Sebago Technics is the reason our back is against the wall, and there's a possibility that construction would not be completed by the date required by the BPI. That puts a new picture as to where the city ends up holding the full bag. If the DOT pulls out their 1/3 of contribution because we miss the construction deadline, that doesn't sound like sound planning. It was very clear that the criteria that TES was supposed to provide for construction was 30 days to have an engineering plan. They didn't do that. That's part of the delay. And at this point, if we stay very focused on that, I am not in favor of removing the condition for the turn lane. It has tripped warrants from studies. That is a safety issue for that corridor, and it is driven by the ecology school's attendance. We know that because of the quarterly reporting that they are monitoring. if anything, we need to start to be more aware because they've expanded their campus, and how many other driveways are they counting? They're usually counting activity on 112 and which driveway they come in and out of. But we know that the traffic counts are from their activity. So let's leave it in place. We do not need to extend the date. Let's deny the extension, find that it's because of their delay and they're not fulfilling the time commitments as specified in the construction loan agreement. And then all of those other possible breaches and stuff, they can start having their attorneys contact the city about getting money back. Let that litigation play out, because there is a ton of information here that to me definitely looks suspicious. But we're only asked right now to extend the date. And I think this board has done it 2 other times in kindness, and it hasn't worked well for the citizens of Saco. So let's do our part. Let's find it tonight. Let's put some solid findings of facts together as to why we denied it, which I think a lot of that is in this construction loan agreement and their inability to pay for the design on time. And then let code enforcement handle it, and let the city council go back to whether or not they'll continue that business partnership agreement, especially if it lapses for date. That's outside of us. We're just asked to move the date, and I am not in favor of moving the date. I am not in favor of eliminating the condition for the turn lane. If we have to add more conditions in this defunct time, maybe we could ask legal counsel if we should do that. Maybe we need to increase the number of the innovative traffic monitoring surveys that they do, so it's more than quarterly, particularly in the summer months. And then a mechanism to their expansion of the number of lots that they're using, number of driveways, so that we have an accurate number of how many people turning off from Route 112 are actually going to facilities owned by TES. But let's move forward and make a decision. Let's get a pulse of where our board is sitting so that we can make findings tonight, because there are other applicants that are waiting here that are contributing more to the city. I think it's important that we move through. We've given this a lot of time, and I think it's time that we can make a decision. And like I said, I would be ready. We could close the public hearing, start drafting some findings of facts as to why we make a decision. Thank you.
Thank you, Jeff. Jim, did you have a comment as well?
No, Mr. Chair. Again, when the time's appropriate, my motion is to close the public hearing.
Okay. Any other thoughts from board members? Joyce?
I had mentioned before that we hear from the applicant again, and then we hear if there's any public response. So I would be in favor of closing the public hearing after we've given people a chance to respond to the applicant's responses and the comments of planning board members.
Sure. Any other thoughts? Catherine?
I agree with Jeff that I have a question whether or not, based on the construction loan agreement, if we can make that finding, or, I agree that it should head back to council if we vote no. And I do have a legal question whether or not if we can even extend it a 3rd time, because it does say twice, and now we're looking at a 3rd extension.
Thank you. So I see 2 courses. I feel a course that Jeff had mentioned, closing the public hearing and making a determination. I think that's one course, specifically with any finding, a clear finding of however the board moves. Or a second avenue would be to table the public hearing and the application review with direction to the relevant parties as to requested information or clarity on any questions we have remaining on the BPI, the CLA, and then with an updated, revised, permanent fixed schedule of construction. Easements in place, construction company under contract, and with a real hard date set in stone that meets the requirements. I don't see a reason to table any further review just to answer a couple questions on the contract, whether it's null and void or correct. And I think we need to be specific. We need all of the pieces to that puzzle. So those are the two, I guess those are the two avenues I see. Again, we close and make a determination, or we table, get additional input from council if we'd like it, any concerns that they may have, any breach of that, of the construction loan agreement. And then again, with that, we need easements in place. We need a construction company under contract with the city, date scheduled, everything, all the nuts and bolts, all the pieces to that. So that's, I guess those are the two steps or avenues or options that I see. Any other thoughts to that?
Mr. Chair,
Jim?
on your second point, I don't think I don't think we need to get into all that because I think from this point on, as I understand it, it's really the city's ball to carry down the field. Because it's the city's, it's the city that has the eminent domain power. It will engage the contractors, and so I don't see how any of that should play into any decision we make, or looking for very specific construction deadlines. Would essentially be asking the city staff to go and lay out their work for us. But I don't think that has anything to do with the actual application to extend the deadline. I mean, if it turns out through some circumstances that the left turn lane never gets built because they missed that June 3rd, 2027 deadline, it doesn't get built. I don't know, and that will fall out however it falls out. But again, all the things I think at the second part of your comments, Mr. Chair, go to the city just doing its work. So I don't think that's really illuminating in terms of this application.
Thank you, Jim. I do agree a lot of that is the city, just for the city to go through and verify. My goal or my intent with that date is to, if we have a date and if the board is looking to extend that date as requested, and June comes around in 2027, that we're not having the conversation again. That's my only, that's the goal, to avoid that potential scenario. But more importantly, creating resolution to this. So, Jeff, you have a thought?
Are you finished?
Yes.
I don't want to cut.
Yep.
My thoughts sometimes come out movement before. I kind of understand option number 2, which is all that date is already set, because when the business partnership initiative ends, that's, it's either we're paying the whole dime on our own. But what I really want to understand is, how do we straight face that, yes, the city's agreement is very clear that they will be hiring the contractor, managing the construction, but it still says that TES has the fundamental role. TS is not a party, and TS has no functional role in the actual construction of the project, except for the design and engineering participation, which shall run through the project. They're still supposed to be coordinating and paying the engineering during construction. If they have the same performance that they had in getting a plan together, how do we expect to have construction crews running if the engineering team's not paid, not there? Then we're going to have a road that's dug up. Then it starts to violate what the MDOT requirements are. That's what I'm saying, is that the faith, that the display that they've brought forth isn't there. There's no harm in us saying no extension, they have the complete right to reapply for another review with no prejudice because it was denied. And then they can also let all the other breach of contract questions start being ironed out. If they want money back, they can have their attorneys contact the city and file suit and say that, well, we're not going to make the deadline. Whatever that is, that's not us. But to me, because respectfully, Jim, I've sat here before, and the big thing is, well, let's see how it plays out. Let's give them that extension and see how it plays out. It plays out exactly like this. Sitting here again, taking hours of public testimony and very little action. Very little action in 7 years. So that's why maybe you sense some of the frustration, but there has not been a lot of progress put forth in a project that should have been, you know, they have very competent people. Sebago Technics is a great firm. We see a lot of their work. All the other applicants are able to get their documents done on time and thoroughly. So that's my hesitation. I don't see that Second Avenue as a fixed date. We already have the dates, and if we don't meet them, then the city's paying $300 and something thousand plus inflation more for a project. We're bankrolling the whole thing. Why is that right for the taxpayers? So, but I would say let's let second part of public comment, let them respond, and then I think we should bring it back and try to find findings and give a motion tonight or a decision tonight, regardless which way it goes. Thank you.
All right, thank you, Jeff. Any other thoughts, Chris?
Yes, I move that we end public comment. Reason being, simply just time. I know we have a bunch of other things on the docket, and just to kind of give out my own personal view, I don't know this project well enough to weigh in one side or the other, but my feeling is that the other members of the board have a feeling one way or the other which way they're going to go, and I think it would be more beneficial if we move forward to a next step of either we table this conversation, say the application is denied, and then move on with other topics. That's my 2 cents on that.
All right, thank you, Chris. Motion made by Chris to close the public hearing. All right, no second, so we'll keep it open, and we'll ask any members of the public that would like to provide any final comments this evening to please come to the podium. Again, state your name and your name and address for the record. Given the time on this one, we'd like to keep public comment to 3 minutes.
Absolutely heard. Thank you so very much for the second round here. Kelly Archer, 185 Bradley Street. The contract zone agreement is the master document. Site plan is after that. Contract zone agreement says the council does extensions, not the planning board. There is something in the planning board and in the planning zone ordinance that says, yes, extensions to you. But if you have a parent contract zone agreement that gives you your rules, the laws, signed, agreed upon, that is what you have to go on. So, and it also has, I think it's 4E, it's 4C, and 4E is breach. You breach it, it's null and void, it's over. As we've learned over year, it's being breached all the time. So right now, it shouldn't even be before you. And ask yourself, why did it come before you? That contract, that CLA was expiring October of 2025. If I was a staff member, I would have that on my tickler to make sure that that doesn't get out of contract, or I get an amendment through the system as fast as possible before it expired. That did not happen. Why did staff bring it to you and not to council? That BPI and that construction loan agreement, and then the third, if you layer it, the third is the mortgage, the fourth is the promissory note. Why did it come before you? In my opinion, and I'm blunt, it was the easy way out. What's going on behind the scenes? That is something that you need to deny this, let them come back for another extension, but it needs to get to council. Why didn't staff put it on the agenda when I've been, and others have been putting it in writing? Get it on council agenda. How many council meetings has there been? Not one executive session on it. On an ICA there was in November, but why hasn't it got to council? They are needed to do it first, then come to you for that extension. You're just doing it, it's being done backwards. Staff had to get to council first. They need to make a decision. Is the BPI, is the CLA, is it all said and done? Then why would they be in front of you for an extension? And with the sunset clause, it is over. So even no matter what you guys do, what the council does, I'm already in conversation with the state. I've already said that to you on 12/16. I'm done with certain things. I'm taking it out of everybody's hands. Let them decide. But this shouldn't be in front of you. You need to get it to council, deny it, let them come back. Once they decide what's going on, then it's a free and clear. Let's talk about right title and interest. With that CZA, and it will be found out, with that CZA and with that site plan, it is null and void. These are the errors that are going on in the city with the contract zone, the repeal of 2021. It is a total mess. And it's being put on volunteer appointees and elected officials. But it's not even getting to the elected officials that is their boss. City administrator is under the purview of council. Why isn't it on there? And I will say, why was there back channel conversations about the loan agreement outside of everything? And why is a state senator involved? Why? This needs to stop. Get it back to council. Don't do it. Thank you.
Thank you.
Good evening, Inga Brown, 161 Simpson Road. I'll keep my comments very brief. I appreciate the time and keeping the public hearing open. Under such circumstances, with such a complicated and multi-layered project, I do think that allowing the public to speak is really important on the item. Two quick things. The construction loan agreement, this was not brought up before, but there is a clause in there about cost overruns. And this is item number 2 on the CLA. If the cost construction for the project is more than the estimated amount of $924,700, then the additional cost shall be recouped by the city and paid by the ecology school pursuant to the terms and conditions of Section 3. That means the city, you, me, the taxpayer, will be paying for all cost overruns on this project. And as Ms. Hilton laid out for you in your presentation, the actual cost of this project is really in the ether and has not really been clarified. The payment schedule for cost overruns is a 10-year repayment schedule. so that the ecology school would be paying back the city over 10 years from 2035, little 10-year reprieve before they have to pay anything back. Starting in 2035 through 2045, those cost overruns would go through that payment schedule. Just another item, another thorn that the council needs to review. I think a going concern by a major public accounting firm is not chasing ghosts. And since this has been part of my life for the last 8 years, here are some dates. In 2018, the ecology school received conditional site plan approval. In November of 2020, they came back to the planning board. Hey, when did you want that turn lane built? You know, there really wasn't a date on there. Can you give us some clarification? The board did. You need to have that turn lane built. Let me get my dates right. By 2022. Please have it built by May 2022. Well, what happens? It's not built. They come back to the planning board again in April of 2022. Hey, how's it going, planning board? We're having some trouble with our funding. COVID, grants, it's really hard for us to do an infrastructure project. Could you give us another extension? Sure. How about November 2025? Do you see the pattern? People show you who they are. This is not personal. This is a contract zone with an attendance site plan with conditions of approval. We don't have projects in the city of Saco that get extension after extension after extension after extension. There's a reason for that. Memory, institutional memory, history. What was that about again? Huh? What happened? It's very poor process. Please send this back to the council. Please send this back to the council. There are so many discrepancies that need council legislative review. They green-lighted the construction loan agreement. They green-lighted the BPI. You are asked for a deferment on a condition of approval to build a turn lane. Does this entity have the financial and technical capacity in 2026 for this project with inflation, with the expansion of easements? I remember the first blueprint for the plan, and Ms. Hilton is correct. Pat Fox said, oh, I hope we don't need any easements. Whoa, that's going to get kind of dicey. Now we have 10 easements. I appreciate very much the time as volunteers that you put into the planning board. I am at these meetings. I know how long you sit at these meetings. I'm exhausted the next day. I don't know how you do it. I appreciate your thorough review. I appreciate this public forum. And I appreciate the fact that residents who come to the podium, who are familiar with the local conditions, who have been to every meeting, the ecology schools, we've had 45 meetings with the city. It's a lot of work. Yep, I've been there too. Been there, done that. I cannot state again, please do your job. Please look at this in a black and white, factual matter with the documentation that you have before you and send it back to the council. Thank you.
Thank you.
Mr. Chair, seeing no one else wishing to speak, I move that we close the public hearing.
Second.
Thank you for the motion, Jeff, and the second, Jim. Yeah? Sorry. Thank you. Your voice sounds different today. Any additional discussion on the motion to close the public hearing? All right, those in favor, Chris?
Yes.
Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 6-0. Back to the board. Any additional thoughts, questions, items to deliberate on?
Oh,
Joyce?
I guess I'll start. I agree with a lot of what Jeff said, which doesn't always happen. In terms of the fact that there are other issues here beyond the simple language of the application for an extension. And maybe we're just in discussion now, but yeah, I mean, I think there's certainly a lot of issues that the city code enforcement could pursue. There could be violations of conditions of approval that have not been, I don't know if not investigated or just not pursued by codes. That's not our department. I'm inclined to agree with you in terms of denying the application, and it may well be that the applicant still moves forward, builds the turn lane. You know, if the city is not interested in pushing enforcement, that's their area, not ours. I'm willing to let things develop as they may.
Thank you, Joyce. Any other thoughts? Catherine?
I agree with Joyce and Jeff. I'm inclined to vote no, while there's these also big questions of whether or not we should be hearing it with the contract zone and the construction loan agreement if they've breached it completely.
Thank you. Just as a side note, let's hold on saying a way we're going to vote, or
Okay.
Because there's no motion on the table or anything. So I just want to make sure that's clear that we haven't made a motion on any direction right now. So any other thoughts from board members? Questions? Concerns? Jeff?
Well, I was trying to, I guess, think of a motion. Are we past that? We have to do everything in the positive, or have we gotten to the point where we can?
We try to begin a motion in a positive format when mostly appropriate. I would say in a more typical scenario where we have specific findings of fact, where we're going through in a particular list, for example, where we're going through each of the section criteria, I think that helps. Where we don't really have that sort of same scenario per se in an amendment, I think as long as there's clear understanding with evidence or direction within a motion, I think that would satisfy. And please, Planner Titleman, give me opinion or correct me if I'm wrong here, but I think that a motion made correctly, I think, would suffice. That answer your question?
Okay. Well, Joyce is usually the talented one at this, but I'll give it a go. I would move that we deny the Ecology Schools application for site plan amendment to amend condition of approval number 9 by moving the date from November 1st, 2025 to June 3rd, 2027. As the board finds, there were lack of compliance with the construction loan agreement entered into the city on May 2024 on behalf of the ecology schools obligation for timely submissions. And which has led to the possibility of the project not being completed in time for the Maine DOT's business partnership agreement.
I'll second.
Thank you for the motion, Jeff, and the second, Joyce. I'm just writing some notes here. I guess Charles or Lisa, were you able to capture some or most of that?
Can I see what you wrote? Yep. And then what I can do.
So I have a motion along the lines of, Jeff made a motion to deny the application, to amend condition of approval number 9 with the dates within, as the board finds lack of compliance with the construction loan agreement and evidence for meeting timely deadlines, which prohibits compliance with the Maine DOT BPI agreement.
Which may
Which
may limit our ability to meet those deadlines.
I was loosely prepared for this. So we have the we have the regular language underneath. So if we want to have the standards, this is just a template, so the language is still there. But to zoom in here, this is what I captured. So this is what I captured through what Lisa captured. So take a second, look at it.
So, Mr. Chair, if I may, I feel like there's a lot to try to put into one motion, and I guess we know the intent of the motion. Is it, can we vote on the motion and then kind of go through our standards? I really want to make sure we solidify this to be as solid and defendable as possible. I mean, do we want to go through, can we go through in kind of one line the criteria, so that if different board members feel like different contracts are maybe questionable, we would want to send it back to council. We could have a few other areas to comment on. I think that would give us multiple areas as to why we formed this opinion.
Sure. I'll just wait a moment here for, just make sure that Charles and Lisa are
No, we're ready.
ready. Okay. So, item A, compliance with applicable standards. The proposed development shall comply with all good neighbor standards, performance standards, the zoning ordinance, and if applicable, standards of the natural resource districts. Board members like to add any comments within that section under that compliance criteria?
Mr. Chair, if I may, I had referenced one of the requests for extensions, and I know Catherine said that she had two, that you had an ordinance that said there were two extensions. I'm wondering if we could, that's one of my questions, do we even have the right to extend it a third time? And I think it would be important to capture that if you happen to have that.
Yeah, that was also my question, whether or not we can even do it. Are you looking to me to try to find it? I don't, but I can try to find it.
Well, in our staff memo, page 204, there's timeline of previous approvals and related activity. And it does reference, well, contract zone agreement amendment, site plan approval, site plan amendment approval, in November of 2019, and then site plan amendment approval, wow, I can't talk, November of 2020, April 26, 22, site plan amendment approval, June 29th, 23, site plan amendment approval.
So that,
I mean,
the extension, I guess, Charles, please correct me if I'm wrong. The extension, I want to be clear that we understand an extension for a site plan approval, which hasn't shown, how's the verbiage, significant completion or substantial completion, that hasn't
There's
gone
a-
through substantial
If
completion.
if I may, there's a
Yes.
couple things at play here, and I'm kind of jotted some things down as it relates to the extension. Generally, the planning board can revise a plan. I just had it up. Hopefully it comes back up. Who knows what I'm sharing at this point. Plan revisions is just in our ordinance. An approved plan can be amended as many of times as it's needed. There's no limit to it. It's at the discretion, in some instances, of a minor revision, the city planner. Otherwise, which is this event, which was acknowledged earlier, that it goes to the planning board, and it's on the planning board to say if this revision is allowed. So there's no limit in our ordinance that says a plan can only be revised once, twice. That just doesn't, there's nothing that I can find in our ordinance. The second piece is on the contract zone element. So city council provided guidance through an SOP late in 2025, saying that any changes to the site of a contract zone that was found substantially complete must comply with the current ordinance in place at the time. Said changes are requested. They're required to file a site plan amendment, site plan revision to properly update it. So that would be going through this process. And then the third thing that I will just reference is that construction loan agreement. The validity of it is not, again, I'm not commenting on that. That has been brought up a lot tonight, but that is also the third place where it would go back to the planning board for a revision. So not to muddy the waters, but I think my short answer to Catherine's question is that this is a valid application in front of the planning board for a revision. The city planner at the time, and I agree with this decision, did not feel this was a minor revision, so that's why it's before the planning board tonight. So that's where we're at in terms of this site plan revision. That's any clarification on that?
Mr. Chair.
Yeah, so real quick, so in that, an amendment to a site plan is different than a site plan approval extension. Those are two different.
There's no, in our ordinance, there is no amendment, there's only revisions. I want to be clear with the language
Okay.
we're using. So site plan revisions are 301F. Planning board extensions, that's a extension on site plan approval. I think it was up, someone said before, maybe H. That is separate from a revision.
Sure.
That
Thank you.
is if someone said they were going to build a 5-unit house and they said, oh, we need 24 months to do it. We saw this a lot during COVID. That's when we would grant it. And that, from my, straight face test of reading that, that's a one-time extension. Anything else would probably have to go to the planning board, which is separate from a revision.
Okay, great, because we do have projects that have current site plans have been to the board, 14, 15 revisions. So 2 revisions here isn't, it's different from an extension for a project that has not begun yet.
Right,
It hasn't
so-
broke ground.
But there isn't a limit on how many extensions.
How many revisions? I think that's where we want to
Okay.
be clear. How many
Yep.
revisions? Yeah.
Okay.
If I may, though, I mean, in all reality, we're not revising a site plan. There is no change in what would normal be, when we look under examples of minor revisions, changes in the record of owner, altering phases, development, adding additional structures of less than 6,000 feet. All of these things are a physical change to the site plan. Here, we're only changing a date. And, technically in legal terms, is it a revision of the plan? But it's a date, it's still an extension. We're basically being asked to make another extension for the time.
Yeah, so those you're listing, those are examples of minor revisions, so that's revisions that the city planner can make in his capacity.
Completely understandable. Right?
But I agree with the term revisions is not aptly defined. This is a revision to an approved plan. The conditions of approval are part of the approved plan, if that answers.
Okay, so Charles, if you could pull that item back up again. Circling back to that item, are there any comments that the board would wish to add to that section?
Well, I guess if we're talking, if we want to look, if we're on H, so what are we, 301 H, I believe, says, I'm sorry, time limits on approval. In this case, 3B, failure to meet a condition of approval within the required time frame. We're there. They have not built the turn lane. It's not completed as of, what was the, December 2025 or
Yeah, I think December 3rd.
December 3rd, 2025?
Well, right, but they applied for the revision before the deadline. So if we determined that the application was timely filed.
And if I may, the substantial construction that they're talking about in 301H, I mean, I'm reading that as substantial construction of the entire site plan. I mean, everything associated with the site plan. And a lot went on at that school, a lot of construction went on at that school. I think within the time period, at least I haven't heard anything to suggest that there wasn't substantial construction of the entire site plan within that time period. So it seems to me that H doesn't apply. It just doesn't apply.
Well, I would typically agree that substantial construction does apply, but we're only talking about words, apparently, very specifically. Failure to meet a condition of approval. They failed to meet condition of approval number 9.
Right, but does substantial construction mean substantial construction of every single condition of approval? Or does it mean that the project was, that substantial construction was ongoing regarding the entirety of the project? So that's why I think that H is kind of a red herring for us. It's, in the same way that I think the issue about, the contract zone, the time limits in the construction loan agreement, that's all council stuff. That's all what the council's dealing with. However they come out on it, they will, and at some level, I don't care. I mean, they're going to do their job, protect the citizens of Saco. But I think that much of, just as another area of 301, financial, financial guarantees or, financial technical capacity, those were standards that needed to be met when the site plan was originally approved by the planning board. It's not now. In fact, the council, in 2024, 6 years after the site plan was approved, they enter into this agreement. And yes, they put some time limits on it. And then, and the applicant had to come back, and the planning board, worked with them. And that's all great. But I think, and I appreciate the public participation and the thousands of pages that we were given about the history of this project. And I appreciate that there's tremendous frustration by some members of the public associated with this application. But I don't think that financial technical capacity has anything to do with this application. I think, the contract, whether they're in or whether they're meeting their contract obligations or not, that has nothing to do with this application. This all comes down to whether or not there was a good cause, a good reason that the applicant presented to go and change the date to June of 2027. And it seems to me that there's a lot of confusion and finger pointing that went on, from the time from May of 2024 until now, well, until December of 2025, when things got all sorted out. And I think that everything's on track now so that this applicant can, fulfill its obligations to the city. I don't know if it will be able to. That's not my issue. I think that there has been good cause, and so there is a motion on the floor, and I guess we're having discussion on it. So I'm not in favor of the motion. I think the planning board is going down really the wrong path when we start paying attention to all these extraneous facts, which are interesting, and in other contexts, they're very important, but they're not important to us with respect to this application.
Thank you, Jim. So, no edits to section A. B, any edits or comments to add to section B? C, compatibility with neighboring buildings. That's not applicable. We're not. The proposal is for an adjustment on a time frame of a condition, so that's C is not applicable. D, natural features. The application request does not affect any natural features, so that's not applicable. Sorry. Caught. E, public safety. Access to the site and structures is adequate for emergency responders and will not create fire hazards or other safety hazards. The application is for a turn lane off-site. And again, the application is for a date extension. So I'm going to say that's not applicable. Jeff?
we can say it's not applicable, but the whole purpose of condition number 9 is for the public safety, for the turn lane and coming off of Route 112. I mean, the whole condition is a public safety issue, and it wasn't built by the time frame. So I feel like we can't just skim over it. That was a previous board recognized it, and traffic circulation and vehicle accounts is all about public safety.
May I make a suggestion here for a couple of these, just to expedite this a little bit? I don't think we're questioning the validity of condition number 9. The only thing we're denying here is, or would be denying, is the requested extension to the project, or to the condition. I don't think we can make a statement that none of the, previously approved conditions are impacted by this. Because I don't think what we need to make sure that is clear in these findings, and I'll relate back to, I'll just pull it up, is our SOP. And again, this is a new format, but same words, so just bear with me. Even in cases where the board denies an application, the board must provide clear reasons for its denial, relying upon the evidence in the record to support why the denial was issued. So I think we can, I think there's an agreement with the board members here, and, correct me if I'm wrong, that I don't think we're debating the merits of a left turn lane. I don't think that's before the board tonight, and I think the previous boards have already debated this. As it relates to the motion and the proposed motion and the findings, I think we need to just say, what's the core reason for the denial? And we can go in and add that these conditions of approval are not being impacted. I think what we have talked about tonight is that this will go into code compliance and enforcement. We'll have to, this will be on the city and city staff to really look into, whether it goes back to the council, whether it goes to code enforcement. I do not have an answer for you tonight. As it relates to this motion, none of these things are changing. So we can just adopt this application does not affect this standard or does not impact previous findings related to the standard. We could copy that down the board. Just a suggestion, unless there's folks here who feel that the application is changing the findings. But we're not suggesting here. I think if we would need it would be a separate conversation with the planning board to get rid of this condition. It would have to come back to the planning board. That was your decision if you were to remove it. I know that was talked about tonight elsewhere, but right now we're looking at deferring or not deferring condition of approval number 9. So just in my professional opinion, we can say that none of these standards are going to be met, and we can focus on this text up here that I'm highlighting. And if we think this is, Member Brochu, I know you made the motion, so if this captures it, and you believe that based on, that you've provided clear reasons for the denial, relying upon the evidence in the record to support why the denial was issued. If you feel that this finding, the language in here says, we could say that the planning board voted X to X, and found that there was a lack of compliance with the construction loan agreement dated May 24th, 2024, on behalf of the Ecology Education Inc. obligation for a timely submission, which has led to a possibility of the project not being completed on time.
Thank you, Charles. I would like to make sure that we are clear that we are not changing or alluding to any other decisions on any other approval criteria, because that's not before the board, that's not requested, we're not reviewing that. We're only reviewing the application before us, which is an amendment to condition 9. We can't review any of the other pieces anyway, right? I mean, they're not before us, they haven't been requested to be reviewed, so we can't review them. So that's, if you agree that that verbiage that you mentioned works through the rest of them, I guess I would tend to agree, where I agree with Jeff that the conversation is about the left turn lane, which is a matter of public safety, but we're not talking about removing it. That wasn't part of an application, so we can't speak on that. So that's, I do want to make sure that we're only focusing on condition 9. So if that's your recommendation for verbiage, I guess I would agree with it. Any other?
Yeah, I mean, we already
Joyce?
made that finding previously, that the left turn lane was necessary for public safety, and we're not changing that finding.
Correct. We're not changing any of the already decided upon or reviewed criteria that were found, whatever those findings were. We're not changing any other findings. So I guess that's, to be clear, that we're not looking at, the thought wasn't to review these to make new findings on anything, but it was just clearly to be clear as to the motion that was made. So I think that, Jeff, yeah.
Yes, I apologize. I was just trying to make sure that we have like findings of facts that really solidify our decision. I mean, I also feel like there are other documents and decisions that need to be done purview of the council and legal review. I don't know if we put that in there, but I mean, this is the heart of it. I just wanted to make sure that it's defendable if it's challenged, that's all.
Yeah, I think we should make a decision on the application before us.
So back to the motion, and the motion is that the board, I guess, how did you have that? It just went away on me. Yeah, I was just going to ask Charles, is there a line that actually says the motion that the board made? I know
It would
it
be
talks
this.
about site plan review.
It'd be this.
The planning board finds, okay, so the planning board finds that there was, I guess I'm wrestling with that it finds that there's no real motion. But let's work through it. So the planning board finds that there's lack of compliance with the construction loan agreement dated May 24, 2024, on behalf of Ecology Education, Inc., obligation for timely submission, which has led to possibility of project not being, the possibility of the project not being completed on time per Maine Department of Transportation BPI agreement deadlines. And therefore denies the application as presented? Is that, like, how would we? I'm only asking because this just says there's a finding, but not, I'm trying to tie it into a motion. Does that make sense to my question?
Yeah. So usually in our findings of fact, there's no motion in here because the motion is part of the record. So this would just be issuing the finding of fact and decision. So you would state your reason for it, and we would say that the planning board found that the project is not, you're making a finding of why you voted a certain way. So you'd be
Which sure, but we haven't voted yet.
Exactly.
Okay.
I mean, we're preparing the findings of fact for the vote in the negative. So it's hard to speak about, this findings of fact that we're writing right now is for the motion in front of us.
I understand.
If you would want to, what we could also do is make the motion, make a decision, and take up findings of fact at a separate meeting, take up the findings of fact afterwards. You don't necessarily need to, you can make your decision and then do the findings of fact as well.
Okay, I understand that's clear now to me. So I think I guess I'll leave it to you to add that verbiage to deny the application if you'd like, but I understand the finding now. So the finding is based on the motion that's on the table right now. So I understand. So, okay, so we can take out the voted part because we haven't done that yet. So, okay. Any other discussion on the motion as we've been presented to us there?
There's a motion on the floor, but it is also 9 o'clock.
Yes, we can't make a motion within a motion. Thank you for the reminder. Any additional discussion on the motion discussed and before us? Okay, motion made by Jeff, seconded by Joyce. Those in favor, Chris?
Abstain.
Jim,
No.
Joyce,
Yes.
Jeff,
Yes.
Catherine.
Yes.
I'll vote yes. Motion passes 4-1 with one abstention. So with that, Charles, is that, I guess you can amend that document appropriately with our findings as necessary? Okay.
If you would like to adopt the findings of fact tonight, we can continue working on it. Otherwise, we can adopt, I won't send out a notice of decision until the planning board adopts findings, and we can take it up at our next meeting. Whatever you guys feel more comfortable with.
Jeff?
Well, respectfully, I'm tired, but two, we are allowed to continue past 9 o'clock to take this business. We have two other applicants who have been bumped and are still waiting, so maybe we should just push through this final piece to find these findings, because that would be permitted in our operating procedure, and we have to move to continue the other two items on our agenda. So do we just stick it out and, you know? I think we're almost there.
Seems like we're pretty close to having final text on findings, so
I'd
I
like
think we
to-
could wrap it up tonight.
I'd like to, make a decision on findings and make that clear tonight. Catherine?
Didn't we decide last meeting we can't take any new business after 9 o'clock? So the two ones that we haven't gotten to tonight, we can't get to?
I believe you are correct, yes. So,
But they can get new dates. But we can determine,
Yeah, we can finish this one, but we
continued
can't
dates.
start new business.
so we've had brief discussion on continuing our meeting this evening beyond 9 o'clock. Can someone make an official motion in that regards?
I move to continue the meeting past 9 o'clock to wrap up the findings of fact on this agenda item and determine continued dates for the other applications.
I would second that motion.
Thank you, Joyce, for the motion and Jeff for the second. Any additional discussion on the motion? All right, those in favor, Chris?
Yes.
Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 6-0 to continue beyond our 9 o'clock deadline and reschedule the remaining agenda items as necessary. So with that, Charles, I think it seems like the board's ready and willing to review those findings and make a determination on those findings this evening when you're ready.
Give me 1 second just to
Sure.
clear this up. So I just want to make sure that, again, the finding reflects, what we're deciding. I think that I want to just clarify with the board that the core reason to deny the application is the failure to comply with the construction loan agreement, as I'm drafting these findings. And is that a concern of technical, financial capacity? That's really where I'm going with this. So I will pull it up here just for your clarification. So the top is just the standard overview of it: applicant, property, development proposed. Subject property is in which is owned, proposal subject to site plan, very standard. In terms of, you voted to find the application complete on December 16th, voted to deny the application on February 3rd, 2026. I don't know why this is not supposed to be here. This should be reviewed. So that's all standard language. Here is where we go into the finding, and there's some language bitten off here below. So the planning board voted 4-1 to deny the application to amend the condition of approval with the description of the project. The planning board finds that the applicant's failure to comply with the construction loan agreement, again, if that's the determination of the board, if that's the primary reason, I want to make sure that I'm reflecting it. So just putting this to really, it seems that you guys are saying this is a technical capacity issue.
Thoughts, comments from board members?
Well, I mean, it seems like we're always trying to group it into the closest word, and technical capacity, they just...
I would support that. I would support that verbiage.
Okay, well...
Yeah. If that's cut to the chase, I guess I would support that verbiage.
I don't know, it's hard for me because the team that they had, if they had paid them, was super technical. They had the capacity to do it, but the applicant didn't seem to have the capacity and timeliness to get it done. So so if you feel like it falls under technical capacity, then I'm okay with that.
Can you find a good spot for that verbiage in there, Charles?
Yeah, I'm trying to find the specific standard so that we can reference it in the finding.
I'd say the planning board finds that the applicant failed to comply with the construction loan agreement entered into with the city of Saco on May 24th, 2024. And the board was also concerned with the possibility that the project might not be completed on time per the BPI agreement deadlines.
Might not be.
I don't like possibility. I don't like the word possibility or might. But I think I do like where you're going with this. Yeah. So the planning board therefore found lack of technical capacity to satisfy the timeline within the main DOT BPI agreement, something along those lines. I don't think the board should use probably, possibly, might.
So do you want to say that the planning board finds that the applicant failed to comply with the construction loan agreement?
I think so, yes. Yeah, I think kill the S on applicant. Sorry, I should say remove the S on applicants. Failed.
Where is this? Sorry.
The planning board finds that the applicant failed. Yeah.
So just one more time, Matt, on the last piece.
Sure, the planning board therefore found insufficient technical capacity to satisfy the schedule within the main DOT BPI agreement. You can spell that out, but.
I'll get the date real quick, too.
Any other thoughts from board members on that verbiage?
I guess I'd just say that last sentence to satisfy the June 3rd, 2027 construction completion deadline. Just move the date up to the.
Any other thoughts or comments or edits on that verbiage?
So do we need a motion to approve the proposed findings? In which case I'll make one.
I would.
Before, sorry to interrupt, do you want me to add this language for all the other standards? Or do we not even want to add these standards as we're not changing the application?
Can we add that verbiage onto our finding?
I like
Yeah.
that.
And then we don't have to have it through all the different letters of the alphabet.
And there's no conditions of approval. It should just not be here, and then I just, don't mind me.
So yes, to answer your question, Joyce, I would like a motion, yeah, when the board's ready. Jeff?
Sorry, Mr. Chair, but, so if we're not, the findings of the June 29th, 2023 Planning Board meeting are not impacted by this decision, with the exception of the date. So condition number 9 would still remain in effect. The date will still be there. There is a chance that they could still hit it, because they can still go for it. And in the process, the innovative traffic solution monitoring still remains in effect. The only question would be, would we want to talk about the traffic movement monitoring to include the additional driveways that they now have? Or do we let that, I mean, because it's been brought up, I mean, their facility has doubled in size, and one of the things that the traffic count does is see how many vehicles turn into that one campus driveway.
I think that is outside the scope
Okay.
of this application.
Okay. Then. If you're
Yeah,
ready.
I agree with the planner.
Could be an enforcement issue. So, Mr. Chair, I'd move to adopt the proposed findings of fact on our screen under the heading Site Plan Review.
I would second.
Thank you for the motion, Joyce, and the second, Jeff. Any additional discussion on the motion to accept the findings of fact as drafted and reviewed this evening? All right, those in favor, Chris?
Yes.
Jim?
No.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes. Motion passes 5-1. So with that, Charles, there's no conditions to review as part of this process?
Nope.
Okay. So that concludes this item? Okay. All right, thank you. So the board made a motion to continue our meeting beyond 9 o'clock here to finish our item 6A and to reschedule the remaining items as necessary. Did the board like to continue with that? Do we need a short recess or we just continue? Continue?
So just to continue the items, I just want to give the applicants a date.
Yes.
So this would move 321 Lincoln Street and 352 North Street applications that were items B and C under item 6 to items 1 and 2 on the February 17th workshop.
Sure, and then, Charles, we have, on the February 17th, we had a few items on that as well, and I think,
Yes, we currently have 5 items on that agenda, so we now have 7 once these are tabled.
and
So we'll have to shuffle things around.
do we need to make an adjustment? The draft that we reviewed may have had the same application or the same property on that agenda already? Or did that get adjusted?
What was that?
The 352 North Street. I have a note.
In tonight's
Oh,
agenda?
No, I'm sorry, the draft I have must have been old, because the draft is different from tonight's. I think the draft that you and I spoke about previously had 352 North Street on the 17th and a different item on tonight, but it looks like we made that adjustment.
Yeah,
Came after,
you guys,
my
at the
mistake.
last meeting, you guys continued it to this meeting.
Oh, I see.
And so if we needed to reshuffle it around, we were going to, but it would be moving those 2 items to the next meeting.
I see. Okay, I understand.
And then we may have to make adjustments for that meeting as well, but we can work on that. It's pretty easy.
Okay, I understand. And the February 17th is our standard meeting, and then the 24th is our special meeting.
Yes.
I'm going to propose to the board, I know we don't always do that, but we have quite a few on the 17th here. Is there an ability to begin a half hour early? I know a few members here might say yes. A couple of us have a hard time getting here before 6 o'clock, but just seeing if we can get a jump on that schedule, because we have a few workshop items that evening. Correct.
5:30 on the 17th is fine with me.
And that's 2 workshop items that evening, Charles?
Yes,
Okay.
as of right now. There's only 1 item that's currently noticed for public hearing that day. So the other 2 applications are completeness, and we could always move things around, so I can update you later, but
Okay.
more time would undoubtedly be helpful.
In lieu of everyone that's waiting, I would make myself available for the 5:30 on the 17th.
Just that one day.
you want to do two? Do you want to do the 17th and 24th?
No, I was just saying just the 17th. Let's start there.
Okay, yes.
Just getting you to commit just on the 17th, 5:30. Okay, so I guess do we need a motion, Charles, I mean, that's agenda and that's SOP, that we can make that decision, great, okay. So then therefore with that, Charles has confirmed that there's opportunity to move the two remaining items on this evening's agenda, which is 352 North Street, map 84, lot 02, and 321 Lincoln Street, map 52, lot 19. And those would be available for our February 17th meeting as items 1 and 2 on that agenda immediately following the two workshop items with a 5:30 start.
You need a motion, Mr.
Yes,
Chair?
sir.
I'll move what you just said.
I will second.
Thank you for the motion, Jim, and the second, Jeff. So any additional discussion on that motion to move items 352 North Street and 321 Lincoln Street to our February 17th meeting as items 6A and 6B immediately following our workshop beginning at 5:30 p.m. that evening? All right, those in favor. Chris?
Yes.
Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 6-0. All right, and then, so with that, our next item, Charles, we have draft SOP
The first
after
thing,
the fact, but
the
go
first
ahead.
thing I would say is that there was just because I didn't do this last time, there was a letter from a member of the public related to the SOP, and that's included in the after the fact packet. I encourage you all to read it. I'm not going to share what was in it. For the point of, Emily and I did not prepare the draft SOP for tonight. We wanted to take a little bit more time with it. We're doing a little bit more research, especially as it relates to the after-the-fact packet. We want to make sure that what we provide you is legally sound and doesn't provide any issues, but is also a little bit more, there's a better system. What we heard tonight, I also sympathize with about how we can add pages, make it a little bit more navigable. I don't know what the word is, but
Navigable, yeah.
it's tough because if we are posting the packet Friday, which is what we're okay with, that's what we're recommending to hold still. The fact of the matter is if people submit public comment over the weekend, we accept public comment currently up until 4 p.m. and I think that's kind of the standard of what we have to do, just figuring out how you guys get it because it's stemmed from a conversation regarding making that decision, having an opportunity to use the after the fact, when do we present it to you. So we're just doing a little bit more research, looking at some peer communities, what others are doing, what are best practices. So we'll bring that to you on the 17th if we feel that there's enough time on the agenda. Otherwise, it'll come on the 24th. So we'll keep you posted on it.
Okay. I think I think we support making adjustments and it being a growing, living document here that we can continually improve. I think that's good, but I think we focus on applications and getting those reviewed, of course. I think that's board priority. I think we'd agree to that. So, okay. With that, any additional general correspondences beyond our after-the-fact packets?
Nope.
Any additional planning department updates or discussions?
None right now.
All right, I guess we welcome Chris. Thank you. This is fun. And glad to have you. With that, any planning board comments? All right, great. Again, I really thank everyone for staying the extra time here and working through some of these items here. So greatly appreciated. And with that, we will adjourn and reconvene on February 17th. Thank you, everyone.